of my senior colleague, madam. Some difficulty to today, madam. Could it be taken up any other day? Tomorrow, day after tomorrow?
After tomorrow.
Thursday.
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 It can be taken for disposal.
Yes, sir.
What are the matters about?
This is a security agency. It concerns the dispute around deployment, and therefore they have taken back the money. And this is the way the board of
Okay, on
protection-
Thursday we'll try
Lordship.
on a request made by Sri S. Bonik, learned senior counsel for the petitioners. Or same petitioner.
Same
Pet-
petition.
Petitioner. Matters are adjourned to be listed for admission on Thursday.
Thursday.
Sri P.K. Roy, learned senior counsel for the FCI is present.
Grateful, Lordship.
Thursday.
In item number 25, by today I have filed an additional application. There may be short form.
The yesterday's matter.
Yes, sir, the matter.
Bring it, we'll have it as the first item. Mr. Sharma is there.
My lord.
Okay, we'll accommodate you. Bring the affidavit. But today is the last date, Mr. Sharma had told. Today is the last date.
My problem.
Mr. Bhuya, you bring the affidavit. We'll accommodate for some time. Let the affidavit come. Okay.
May please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 19, lordship.
Yes.
Actually, the problem here is that my senior Miss R.D. Majumdar is conducting a mediation training program, which is
Okay.
organized by the MCPC for 1 week, lordship. The matter may come up next week. Old matter, but still, lordship. Some difficulties.
16 matter.
16 matter, lordship. Only for next week, lordship. Tuesday.
A request has been made. A request for adjournment has been made on behalf of Miss R.D. Majumdar on personal grounds, full stop. Considering that this matter is pending since the year 2016, a short accommodation is granted, directing listing of this matter on Monday next.
Tuesday, lordship, hearing day, it will be
Doesn't matter, Monday.
obliged.
Monday date deliver, 24th.
Chief,
Yes,
Chief, I'd like to mention item number 1 for admission.
1.
Yes,
Yes.
Lordship, with the consent of 5 others. Lordship, I want to file affidavit.
You want to file affidavit?
3 weeks time may be granted, Lordship.
You have not filed affidavit in the matter of 2023. Why?
No, Lordship, I'm for the petitioner. I got the affidavit yesterday.
Oh, you'll file a rejoinder affidavit.
Yes, Lordship.
Affidavit against whom?
Against
against the
responsible.
KAC.
KAC, okay,
We have filed our affidavit just yesterday, Your Lordship, additional affidavit.
okay.
And it's not on
You,
record.
you are Yanthan,
Yes, Lordship.
Miss K.L.R. Yanthan, learned counsel for the petitioner, praised for and is granted 3 weeks time to file rejoinder affidavit. Full stop. List on, we give a date, madam. Today is 18th. We'll have it on 9th of September. 9/9.
Lordship, with the consent of the address, I had to mention item number 23 of the list.
Yes.
Lordship, in this case, we are led by Dr. Saraf. So he's out of station and he was about to come yesterday, he could not come, Lordship. I pray for a short accommodation.
Yes, Mr.
My
Pathak,
lord.
On a
He is
request-
not there, my lord.
on a request made on behalf of Dr. E. Sharaf, learned senior counsel for the petitioner, matter is adjourned to be listed on, we'll have it on 1st of September. Oh, 1st is a holiday.
First.
We'll have it on 3rd of September.
Much of
3/9.
May I please, Your
interim
Lordship?
order passed earlier, shall pass.
Interim order passed earlier stands extended till the next date of listing.
May I please, Your
Yes.
Lordship? Lordship, I beg to mention a writ petition filed yesterday for listing in motion.
Motion, yes, you can have tomorrow.
Obliged, Your Lordship.
May I please, your lordship? My lord, the contract was submitted on 12/8, my lord. We are challenging the arbitrary termination of the contract, my lord. In fact, what had happened, my lord, the date of commencement was to fix, my lord, on, my lord, having, my lord, 90% of the, my lord, the way, because it's for construction of bridges, my lord. 90% of the way, my lord, right to, my lord, access of the road.
Who is the other side?
Other side, my lord, the Lord, the,
Who's the owner?
Lord, other side, Lord, is my lord, the direct border roads, my lord.
Border of CGC.
Border CGC, my lord.
Who? Mr. Roy.
Mr. Roy was.
What about the arbitration clause?
Arbitration clause, my lord,
You're challenging a cancellation of a contract in
my lord,
proceeding.
my lord, we were not given, my lord, the opportunity, my lord, for dispute resolution. Nothing was given, my lord. And this is totally arbitrary, my lord.
No, you can
Understand,
raise,
but-
you can raise this dispute now
But then,
that
my lord,
that the cancellation is bad.
my lord,
There is a forum. How do you, this ultimately will be hinging upon factual disputes.
my lord, factual disputes are not there, my lord. That's what I try to, my lord, point out. Because they've admitted this position, my lord, and in spite of that, my lord, they're going ahead with this, my lord, termination. They've gone ahead with the termination. What,
Now termination, we cannot stay a termination.
my lord?
So what will you
Well,
have? You can file for damages tomorrow.
Well, that is there, my lord, but then so far as the bank guarantee, my lord, has been, my lord, invoked, my lord. It has not been encashed as yet, my lord. The morning till morning today.
Where is
morning,
Mr. Roy?
my lord.
Name shown or not, Mr. Doctor?
Name perhaps not shown. My lord. He was aware of this. I told him, my lord, yesterday.
Yes, Deputy SGI has been shown.
Yes, my lord. No, he was aware of this, my lord. I told him yesterday.
Okay, he may not be aware that this will be this first item. Mr. Sharma's matter has to wait. Some affidavit is coming. Just a moment.
My lord, my lord, my lord.
Let him come.
My lord, no issue.
Lordship, in this matter, today we have filed our affidavit, Lordship.
You have filed affidavit. Rejoinder affidavit.
Reason
Yes, what is the matter about? No, if you, we can take it to the, what is the issue involved?
The game of the business is the LOA suit to the private restaurant. So regarding petrol pump.
The allotment to,
Yes, number 6.
has been challenged.
Yes, ma'am.
If yes, you can proceed with the arguments.
Lordship, actually, in this matter, my line friend, Mr. P. Verdras, is on legs, Lordship.
He will argue.
Lordship,
Okay.
the matter shall take some time, Lordship.
Okay, when we can have day after tomorrow?
Yeah, after some time.
After some time, if you start, Mr. We can,
Can you get
2 we cannot say. If we finish the matters, we'll not sit at 2 o'clock.
If your Lordship may kindly fix a date, Lordship.
We can have it today after the other matters are over, when he comes, if it's possible. Otherwise, we can have it on Thursday. Okay. Let Mr. Bharadwaj come then. Okay. Yes, Mr. Roy. Mr. Dutta. See, he is aggrieved by cancellation of a contract 12/8/2026. So the immediate question from this court is the arbitration clause. But he is on the other aspect, invocation of the bank guarantee. What is the state?
Please, your Lordship, my instruction today will be. We have approached the bank, Lordship. Will be. Otherwise, Lordship. The disputes.
But Mr. Dutta, how do you have a restraint order for invocation of a bank guarantee?
Yes, Lordship.
Well,
It's a very, very limited scope.
because it's a consequential order to the termination, man. Otherwise, my lord, the.
No,
and the-
bank guarantee you cannot restrain unless there is a fraud element involved.
My lord, here,
That is the law.
that's what what I'm trying to impress upon the
These
lordship.
are absolute right
I
to invoke a
understand.
bank
I
guarantee.
understand, but here what I'm trying to impress upon the lordship, my lord, is that the clause they have invoked, my lord, for termination of the contract, that itself is not applicable, my lord. My lord, they're admitting the position, my lord, they did not hand over the land, my lord.
No, Lordship.
And I'll show, my lord, I'll show because they're from their own documents, my lord.
But restraint order for a bank guarantee, difficult. Unless you make it a case of fraud.
My lord,
The legality or otherwise can be examined, but you cannot have a restraint order.
my lord, basically, my case is this is the consequential order, my lord. If the termination itself is bad, my lord.
No,
my lord,
that is what we are trying. Termination, tomorrow we may interfere,
my lord.
but we cannot prevent a bank guarantee from being invoked.
The lordship see the conduct, my lord. That's what I'm trying to
No, no,
impress upon
see,
the lordship.
let us see the law on bank guarantee invocation.
My lord, that's there, my lord. I understand. Law. Bank guarantee will is a separate contract, my lord.
And
It's very limited, my
can
lord.
it be restrained? Can it
It's
be
very
stayed?
limited, my lord.
Can an injunction be passed?
But once, my lord, lordship.
These
my
are
lord,
different matters, bank guarantee.
that I understand. But the
You
lordship,
make out a case of fraud,
lordship sees, my lord, the way of
but
the.
legality, if you are questioning, we'll examine, but will it necessarily require restraint order?
Well, otherwise, my lord, my
They
lord,
almost have a
I
gain
am
of
entitled to, my lord, I am entitled to use some, my lord, they if we withhold the payment, my lord, they're supposed to make the payment, my lord, for the purpose of, my lord, carrying with the constructions. They have not done, my lord.
How
They
much
did
is
not-
the bank guarantee for?
my lord, 32 lakhs and odd, my lord. My lord, they have, my lord, not given me the right, my lord, to waive, my lord, the land is not been given, my lord.
That is Mr. Roy is denying.
Denying lordship.
No, but I'll show from the records. My lord, I'm not saying, it's not a verbal submission, I'll show from the record, their own records, my lord. They, my lord, themselves, my lord, on 16th of March 2026, they've admitted the position, my lord.
But we may not be inclined to pass an order of stay for bank guarantee.
Lordship will kindly see, my lord, annexure 6, my lord, page 455.
Had it been some other case, yes, we would have
I
considered.
understand, my lord,
But bank
my lord,
guarantee
the
is
limitations,
difficult.
my lord.
Bank guarantee is
Yes, my
difficult.
lord, the difficulties, my lord, in saying the bank guarantee.
What are the case laws? Have you got the case laws
Case
on
laws on, my lord, on the.
bank guarantee restraint?
Bank guarantee restraint, I have not got any case. laws,
Cases
my lord.
are all against
It's true, my
you,
lord, they're against me, my lord.
except on a case of fraud.
Well, that I
Then you
understand.
can invoke a
That I
debtor injunction. You are approaching a constitution code.
Yes.
But still then we follow the principles.
No,
Unless fraud is involved, we do not normally restrain
I
invocation of bank
understand that, my lord.
guarantee.
I fully, my lord, understand.
Here you are not alleging fraud.
No, my lord, they're not, but then, my lord, the way that termination is made, my lord, it's totally arbitrary, my lord.
If Mr. Roy is magnanimous enough to make a declaration that they are not invoking, otherwise,
Today it will be. Bank.
Lordship, you kindly see, my lord, page 4, well, just for a moment, my lord, for my sake, my lord. Page, my lord.
no, we can
455,
issue notice, we can examine the
my
matter.
lord.
But interim order is difficult.
Lord, you see, my lord, that there's a clear recommendation, my lord, and
See, termination we cannot stay.
my lord,
It's 12/8/2026, we cannot stay. And bank guarantee, we can at best issue notice on the bank guarantee,
but that will be, my lord,
interim prayer.
my lord, that will be, my lord,
If they are considerate enough not to invoke today, we can have their views and pass an order. Heard,
but till then, my
Sri
lord,
M. Datta, learned senior counsel, assisted by your name. What is your name? D. Malakar, for the petitioner, who has put to challenge an order dated 12/8/2026, by which the contract with the petitioner has been terminated. Full stop. The petitioner is also aggrieved by the action of the authorities to invoke the bank guarantee. Full stop. Amongst others, it is contended that such termination is without any justification or even justification, as the site was not handed over to the petitioner to enable it to perform the contract. Full stop. Para. On the other hand, comma, 3 SS Roy, learned CGC, appearing for all the respondents, has strenuously opposed the writ petition by contending that the action is justified. Full stop. He has also submitted that there is an alternative remedy available, and therefore the writ petition is not maintainable. Para. Be that as it may, comma, let notice be issued, returnable on returnable on we'll have it on short date, 9th of September. 9th September. Bring the instructions. 9th of September 2026. Sri Roy, the learned CGC, accepts notice on behalf of all the respondents. Let extra copies be served upon him. Para. Sri Dr. The learned senior counsel pays for an interim order, which however is opposed by the learned CGC. Para. So far as so far as the termination or so far as an order of termination of contract is concerned, comma, there may not be any scope for passing any interim order, full stop. At the same time, comma, a restraint order for invocation of a bank guarantee can be passed only on certain extraordinary circumstances which does not appear in the present case. Para be that as it may, comma, let notice be issued on the interim prayer on the invocation of bank guarantee, returnable on the same date, i.e. 9 September 2026. Full stop. Thursday.
Till then, some restraint, my lord.
Difficult. It will be wrong precedent.
Oblige, Your Lordship.
It is however made clear that any action taken in the meantime shall be subject to further orders that may be passed by this court.
Deployable.
Affidavit has
What happened
come.
in this case, Lordship,
Affidavit has come.
Yes, yes. Lordship, I have read the brief yesterday. Actually, Lordship, this is not, I have been an engaged counsel. Lordship.
No, doesn't matter.
Yesterday, I had not.
No, what do you say? Where is Mr. Nath?
Is coming, madam. The madam order has not been done. Madam, court has informed the agency after the 11th September. Before that, it will be after.
In this case,
But
Lordship,
his
you-
last date is today.
Yes, madam.
it is
What is the order?
Regarding my lord,
No, what is the order which has been passed by the court? You must be having a fair idea what is the order about. These two clauses have been set aside.
sir. This clause has been the authorized agency has been there. That is also there. Only my lord. Cooperative society, that was only.
Who does pass that you have to go for a corrigendum and all that?
Mr. Sharma, let us wait for a while. We'll take up your matter on priority basis. Let Mr. Nath come.
Yes, yes.
This additional affidavit have you gone through?
Yes.
ये नाथ हर लोग लगे मत लीजिए। Item
Lordship, may I please your lordship? Lordship, my senior Mr. K. Chaudhary, sir, is on legs in court number 10. Therefore, I'd like to request for a passover for time
that
being.
railway matter.
Really matter, that's
We have almost heard this matter, I think. We don't have the notes. We do not know where the notes are. Police illiterate, thorough. Can we have today?
we can have.
After he comes, okay.
Yes, we'll be here. Okay.
No, note of it. Put that hoodie. General log motivation of note of it. It's not like it, sir. Yes, item 7.
Also, the instructions were sort of.
Who's for the petitioner? Yes, Mr. Senapati.
Yes, Lordship.
Item 7.
Yes. Lordship, just give me. Your Lordship, there was an NIT floated, which your Lordship will find.
Pleadings have been exchanged.
Everything is
We can
completed.
take up for disposal.
Yes, the
Mr.
matter was also heard.
Mr. Gupta?
No, it can be taken up.
Hmm?
The instructions were short from what I received the instruction, but the clarifications on the railway board circular
Okay.
was. Not from. Because there was certain requirement of the tender conditions, which as per the railways, it was not there in the existing tender. So the authorities decided to discharge the tender and float a fresh tender with those additional criteria for that would
eighty case, case number this, note three होता है एकदम. 87. Yes,
Not, authorities have decided to discharge the tender, my lord, in view of certain additional requirements, my lord, which were there, which the existing tender conditions did not have.
when did you take the decision to go for a fresh tender?
During the process of evaluation, my lord, because the power of discharging tender, my lord, that is always there with.
No,
the
you,
authority.
we are not doubting the power, but you exercise the power with some reasons, some justification.
Well, certain clarifications have been given by the authority, my lord.
What are the clarifications?
Paragraph 2.
This you had not put in the affidavit.
It is there, my lord, it is there.
This part is there. So what is new in this? Is there anything new in this instructions?
So this is the only thing, Lord, that the my lord, requirement of adequate experience of slope protection, my lord, in mountainous region. That particular clause was not there in the tender condition. And my lord, as per the revised railway board circulars, my lord, those have to be taken into consideration by the authorities. In that view of the matter, my lord, that discharge was done. And the petitioners will have, my lord, full liberty to participate in the fresh tender process. If they, my lord,
But there are two communications 13/3/2026
well,
at 116 and 130 that the guidelines will be prospective in nature.
well,
So can you go back and
well,
their technical responsiveness was evaluated by taking into consideration the earlier criteria involved, and they seem to fulfill those.
well. What is the value on that aspect, my lord, that's regarding slope protection?
The experience which he
there
has,
should have been a better, yes.
will
that-
not
that would
will-
suffice.
why he has experience of tunnel or something, if you remember correctly.
Yes, yes, my lord. That in paragraph 2 of the instruction, my lord, you have stated that. the two
Mr.
words of-
Senapati, have you got a copy of this
No,
instructions?
yeah.
Please hand over a
And I
copy
will-
to him. Unless there is something new, we'll try to examine the matter on the basis of the materials.
Well,
Okay, day after tomorrow we'll have this. You have a look at this, Mr. Senapati.
Not so.
We don't think there is some
There's nothing.
extraordinary,
This is already.
something
taken.
else which has not been dealt with in the
Yeah,
affidavit. But still then, you have a look
I'll do that.
and day after tomorrow, okay? Pursuant to the last order dated 7/8/2026, comma, Sri H. Gupta, the director CGC, has obtained certain instructions, certain written instructions dated 12/8/2026. Full stop. Let a copy of the instructions be handed over to Sri D. Senapati, learned counsel for the petitioner, for his response, and the matter be taken up for consideration on Porohi, you have it, right? 2020.
Not-
Okay. Interim order, is there interim
Yes,
order?
we are okay.
Interim order passed at stands extended till the next date of listing. But day after tomorrow, on the,
Uh,
on the understanding that we'll go for final disclosure.
Much.
Exercise case. Exercise very good. My lord,
Today something is happening
somehow.
for something or the other. None of the cases. Exercise, yes, Mr. Gogo, finally.
My lord, we have a bit weak in this case, my lord. Let us be honest to it, my lord. My lord, what has happened in this case? We
You have not, you have filed your return.
My lord, the problem is let them do it. I don't know what is their
Let
affidavit.
them file, we'll have
My
it
lord,
tomorrow.
Yes. Well, only one point, my lord, here. We have done a wrong that we continued our bar beyond 12:30 PM. That's an admitted position.
Hmm.
We continued till 2:45 because there was a party, private party. Now, incident has happened, my lord, on the particular date. 2-3 guests came, 2-3 particular, the customers came, and at 11 PM, that was open, 11 PM. It continued because there was a private party. Now, these particular 2-3 boys, after my lord, went from this bar and they met with an accident. That's the only problem, my lord, here. And ultimately, my license was placed under suspension, my lord, in the month of April 2026, my lord. I have given a reply also to that, my lord. It's an admitted position.
I have the affidavit, we'll have it tomorrow. Tomorrow,
Yes.
but give it an advance copy to Mr. Sharma. Okay, heard. Sri D. Das, Learned Senior Counsel, assisted by Sri R. Sharma. Full stop. Sri R. R. Gogoi, Learned Standing Counsel, Excise Department, has however informed that the affidavit in opposition would be filed during the course of the day. Full stop. As urgency has been expressed, list this case.
Let me on when Thursday. Thursday is a
Thursday we fixed 2 matters, but doesn't matter, we can have it. As urgency has been expressed, list this case on Thursday next, along with the affidavit.
yes.
Deeply.
Thursday date, diba, huh?
Deeply.
May it please the Lordship. This is otherwise a challenge to an award of the Labour Court. But I am faced with one difficulty. If you Lordship will see the order of 29/2024,
Yes.
the LCR that had come from the Labour Court
Hmm.
seems to have been misplaced in the registry. Thereafter, an order was passed.
Never seen, but we'd go.
What I am trying to submit is, thereafter, an order was passed that let us try to reconstruct.
Yes.
We have failed to reconstruct from our side. And now the entire case hinges on our evidence. Because what the Labour Court has found is that we have not
Who is on
exhibited.
the other side?
Other side, MS M. Horali. As I can see from the order,
Yes, Chakraborty is there. Suman Chakraborty is there. I think Suman
yes, S.
Chakraborty.
Chakraborty and Borua.
Where is Mr. Suman Chakraborty? Mr. Chaudhary? Your friend Suman Chakraborty. I think he, either Suman Chakraborty or Santanu Chakraborty.
He used to. So, my instruction is on our last occasion, Mr. S. Chakraborty has stated that he has got no connection with the client.
S means Suman or Santanu? Suman Chakraborty. Okay, whoever it is, 2010, but we'll hear and try to dispose this of. Yes, what is it?
If your lordship will come to the award directly, then. But if the basic plank of my argument is that
3, 9, 4 of 10.
there are total respondent 4 to respondent 27 are the workers. There are total 23 workers against whom
You are the management of this tea estate.
management of the Ghilapukuri tea estate. Now, there has been an allegation of unauthorized absenteeism and encroachment of garden land against 23 employees, 23 workmen. These are the two grounds. Unauthorized absenteeism. Number 2 is the encroachment of garden land. And number 3, there is another ground of disobedience because when we wanted to serve them notices for our domestic inquiry, they had refused to accept them. So these 3 were the issues upon which the Labour Court had considered and adjudicated. And the total number of workers are 23 number of workers, respondent number 4 to 27. Now, since the exhibits or the lower court records are not there, if I may just refer to my averments in the petition lawsuit.
First, let us read the award, I think. That will be
Yes, Lord.
convenient.
Yes, Lord.
Page
The award
20,
starts at
20,
page 26.
26.
Yes, Lord. May I take your lordship to page 30? Because the award first deals with the
Mr.
domestic
Sharma, what is the date?
lordship.
Date of the award?
The date of the award is
19th August.
on
2008.
19th of August 2008, page 33.
Labor Code Dibrugarh.
Labor Code, Dibrugarh. Yes, your lordship.
Okay. Please read.
May I
It is-
take your lordship to page 30 of the
Whether the termination, that termination was the issue.
termination was the issue, and the Labor Court has held that since we have not been able to establish the grounds on which we have charge sheeted them, therefore they were reinstated.
Okay.
Now, the first part of the award deals with the fairness of the
Now what is
domestic
the stage? They have been reinstated.
No, they have not been reinstated. Stay as an accused. I
Was,
think there was a stay order offered.
there is a stay order.
Our records are also very incomplete. That is why some
Doesn't
difficulty.
matter. You try your best, we'll try our best. But matter has to go. 2010.
Because the difficulty is, lordship will have to draw a conclusion whether I exhibited or I did not exhibit. But
Let us
then
see,
since
let us
the
see.
LCR is not there,
We'll try to do whatever is best.
yes, lordship. Now, lordship, the award, the first part of the award deals with the fairness of the domestic inquiry. Now, that has been held against us. We also accepted that, and then we proceeded to adduce fresh evidence. So, from page 30, your lordship may see. Page 30, may I read from the second paragraph from the top, lordship?
So once the fairness was put to question, it has been decided against you. You
We
had
accept
adduced fresh evidence in the labor court
Labor Court. And
as
we
the
accepted
primary
that.
court.
Yes.
Okay.
So therefore, I am reading from that stage.
Yes, yes.
Because the earlier would be redundant. Now.
Okay.
So if your lordship will come to page 30,
30.
30. Part of the
Mr.
award.
Chakraborty, not connected.
My lord, the thing is, in this case, Mr. Nilupal Burua is the main counsel matter. In fact, I missed this item also, but around 2 months back, I tried to get some information and he also is not in touch with the union. And I'm told that many of the affected workmen have in the meantime expired.
But we are deciding this matter, 2010. We cannot afford to, okay, whatever is there, even the LCR is not there.
LCR, that is also a problem because perhaps it came to High Court and then it got misplaced.
And there were search, but it was not being able to be located. Nonetheless, if you want to participate in the hearing, you are welcome. Okay, have a look.
So can I suggest one thing? Can it be sent to mediation if possible?
Not mediation.
Since he's
No,
also
no, the clients will not come. Who will mediate? Mediation amongst whom?
since he's also
From the
if
advocates.
you can contact with the
You
client.
can have a mediation.
Lordship may take up this matter day after tomorrow. In that case, whatever material.
No, you are not in the case. We are asking you to assist us. Just have a look at the records. You are not adjourning 2010 matter. The award is a very short award.
Short award.
Mr. Sharma has very fairly stated the fairness of the domestic inquiry was put to challenge. That has been held against him. He's the management. So they have adduced evidence on merits. So we just examine whether the conclusion arrived is okay. And there is also one more relevant factor. 3/3/2010, there is an order of stay by the court. There is no order for even vacating, no 17B application. So those will also have a bearing. Let us see.
Another thing, my lord.
You have a look. By the time he finishes, you'll have a look.
So may I
Yes.
take a lordship to page 30, the second paragraph from the top.
Yes.
May I
As,
read?
as the,
As the workmen were dismissed after holding domestic inquiry regarding the LA's misconduct on their part, this court initially took up the question of validity of the said domestic inquiry for decision. Accordingly, the management
this is
side,
as per Ludbud.
Ludbud, yes.
Okay.
Accordingly, the management side examined 2 witnesses, while the workman side examined 25 on that question. After hearing arguments of both the sides, this court held the said domestic inquiry to be invalid.
Okay.
So now, therefore, fresh evidence now.
Yes.
Thereafter, as desired by the management side, both the sides were asked to adduce evidence on merit. Accordingly, the management examined 1 witness, while the workman side examined 3. Arguments heard also perused the case records, including the evidence record hearing. Issue number 1.
Yes.
On perusal of Exhibit 120 to Exhibit 143, charge sheets reveal that the following allegations leveled against the concerned workmen by the management. Number 1, being the employee of Ghilapukhuri Tea Estate, the concerned workmen remained absent from their duty since various dates mentioned in the charge sheet without any valid ground or without information to the management. So this is one charge. Charge number 2, though provided with quarters in residential labor line of the company, the said workmen have engaged themselves in encroaching upon company's highland, kept fallow for tea cultivation, and by making illegal construction over such land, they have damaged the topography of the soil, causing substantial damage to the company's property. Number 3, been served with a notice on various dates and several reminders thereafter, they have not complied with the direction of the company, which amounts to insubordination on their part. So these are the 3 grounds: absenteeism,
Yes.
encroachment of
You have
land.
already,
and-
highlighted
Yes.
3 grounds.
Yes,
Okay.
Lord. Now, may I just read the
Evidence.
thereafter, Lord? Yes. Let us now consider the evidence on record to see whether the management is able to establish the said allegation against the concerned workmen. Regarding allegation number 1, MW1, the only management witness examined in this case, in his evidence does not say that the concerned does say that the concerned workmen remained absent from work, but he does not say anything supporting the allegation that they did so without valid ground or without informing the management. On the other hand, all the WWs, that is workmen witnesses, have claimed in their evidence that the concerned workmen never remained absent from their duties at the tea estate, and the said claims of the WWs have been disputed by the management, have not been disputed by the management side by cross-examination them on that fact. Hence, I find and hold that the allegation number 1 against the concerned workmen is not established. Now, herein my argument is, we had exhibited a total of 462 documents. That is a part of my pleadings. Now, the labor code had proceeded on the basis that we have not given any evidence in that regard. So that is one aspect where your lordships would have to see the exhibits, whether this was a ground that we have taken or not. Now, regarding
Where is your written statement?
written statement, your lordship will find.
Where you have mentioned about this 462 documents?
No, it is not in a written statement.
No, some mention will be there.
Yes, some
there will be
mention is
documents.
there in our writ petition. At paragraph 13, Lord.
Where do you have your evidence?
We have not annexed the evidence with
You
our
have with you.
Lordship.
You have with you.
That is not there. That is the difficulty.
Or not
Because
with
the
you.
normal practice is we normally give the award and the written statement and file a.
No,
writ petition.
that not for the purpose of filing. You normally retain. It's not with you.
It has come from a different chamber, so those
Okay.
records are also not with us. Lord.
But you say that there were documents numbering 462 which were
Paragraph
exhibited.
13 is our categorical averment to that effect, that a total of 462 documents were exhibited
Paragraph 13 of the writ petition.
of the writ petition.
Page?
If your lordship will see page, your lordship, page 10, page 10. I'll just read that line, lordship. In fact, MW1 has exhibited 462 documents, including
You're reading the pleadings
pleadings.
at page paragraph 13.
Yes, lordship.
Just a minute.
Just to complete that aspect, therefore I'm reading that, lordship.
Yes, just a minute.
Because this has a bearing on all the other findings also, the 3 findings of the labor code. Page 10, paragraph 13.
Yes, please.
Yes. Shall I read the entire paragraph, Lordship?
462.
Yes, Lordship has seen that. In fact, the MW1 has 462 documents, including the envelope, which were returned to the management. The MW2 had exhibited the attendance register to show the continuous absence of the workmen without leave or permission. The learned labor court, while passing the impune award, did not take note of any of the exhibits made by the management and had most perfunctorily passed the impune award, and as such, the impune award is liable to set aside. So this is the main argument that I would like to raise before Lordship, that the labor court had went on a very perverse and a perfunctory manner and have not considered what was available on the records and have come to this finding that we have not exhibited. Now, if I take my Lordship back to the award, page 31.
Luckily, your verification is proper. You have properly verified. Otherwise,
looking at
difficult.
that.
No, if there is nothing, we have to read. Look
Yes.
at the affidavit, how you have verified.
Yes. Now,
Yes.
if I take your Lordship to the award, back to the award, that page
Yes.
31. Page 31, now regarding the discussions regarding the allegation number 2 or the charge sheet point number 2. May I read?
Yes.
Regarding allegation number 2, the only management witness examined by the management in his evidence says that the concerned workman took over the possession of the land belonging to the T estate covered by NRL grant number so and so, constructed houses thereon and dug arts there. He, however, does not support the allegation that the act of the said workman caused damage to the topography of the soil and substantial damage to the company's property. He also has not submitted and exhibited any document in the case to substantiate his claim that the said land belonged to the T estate. This is again another aspect also. During his cross-examination, the workman side has denied that they took possession of such land belonging to the T estate. On the other hand, in their evidence, all the WWs have claimed that the concerned workman concerned never took possession of such land belonging to T estate, which means that according to them, they also did not construct houses thereon. The said claims of the WWs not disputed by the management of cross-examination, the WWs on that fact. Hence, I find and hold that allegation number 2 against the workman is not established. So again, there is a finding that we have not submitted and exhibited any documents to this regard, which I would like to again counter by saying that we had submitted and it was a part of the entire exhibits that we had submitted. Therefore, again, a reliance on the lower court records is very imperative in this matter. That is why I was telling a Lordship that this is something that has to be considered and looked into by a Lordship as to how we can overcome this.
Well, what
aspect.
about your conduct in not cross-examining the witnesses of the
I
workman?
cannot better that now. I cannot better that. It has not been cross-examined, so it's a part of the fact that is there. Maybe our records were so convincing that we did not have to cross-examine them. That is what I could.
And you fall back on the paragraph 13 even in this
Yes, paragraph 13 as
462,
well as Lordship paragraph 14 and paragraph 16.
14 and 16 also.
Yes, paragraph 14, which deals with this encroachment aspect. May I read paragraph 14?
Yes, please.
That the petitioner begs to state that the applications made by the workmen to the circle officer for allotment of patta to them, which they were occupying inside the garden, were exhibited before the labor court. However, while passing the impune award, the learned labor court, without considering the said exhibit, held that since the workmen claimed that they have not taken over possession of the garden land, as such, the allegation made against them are not established. So categorically, we have said that there was an application on record wherein these workers had made application for a circle officer to convert the land into their own name, which was exhibited. This is our case, which has not been considered. Having not been considered, the labor court proceeded on a finding that it would not be established. Had this exhibit have been considered, probably the result would have been different. And paragraph 16 is on the third allegation of absenteeism that your Lordship will find at page 11, paragraph 16. May I read? That the petitioner begs to state that from the deposition of the witness and from the documents exhibited, it is clearly evident that the workmen were continuously absent without any leave or permission for a long period, and they had illegally encroached on the garden land and constructed houses thereon, and made application to the concerned revenue office for settlement of their plots of land in their favor. As such, the findings of the labor court, without discussing any of the document exhibited, is absolutely illegal, arbitrary, and without jurisdiction. Failure to consider the exhibited documents has vitiated the entire award. As such, the same is liable to be set aside and passed. Our entire case has been built on this aspect that the labor court did not consider the exhibits on record, did not consider the materials on record, and had proceeded on a perfunctory manner and have come to a finding that the charges were not established. Now, if I again take your lordship back to the award regarding the last allegation, the third, wherein we had said there was a disobedience on their part because of not acceptance of our notices. Regarding allegation number 3, page 32.
Yes.
According to MW1, the only witness examined by the management, despite notices being issued several times, the concerned workman did not accept the notices. He, however, does not support the allegation that the said workman did not comply with the direction of the company, which amounted to insubordination on their part. During his cross-examination, the workman's side has claimed that no notices were ever given to them. MW1 has also not submitted and exhibit any document to substantiate his claim that indeed notices were served upon the concerned workmen, or that notices were issued to them, but they did not accept it the same. Again, a finding that the documents were not submitted. So on all the 3 allegations, the only finding of the labor court is that we have not adduced any exhibit to prove our case. Whereas our categorical case has been that we have adduced each and every evidences. All those 462 documents that we had exhibited in our evidence speaks volumes of the fact that these allegations could have been found to be true, correct, had these exhibits been looked into by the labor court. This is the long and short of my case, but then I would have now relied on the lower court records to produce those documents out of the exhibits before lawsuits. And one aspect, yeah, list of documents. So one thing that we have been able to get is the list of documents filed by the management. Now, if I may just place this, but this is an unsigned document. I do not know whether this was actually what was filed, but then I could find it from the records. Records of the advocate from where the lower court advocate from whom I have received it. R.K. Borthakur, advocate for the management. I think in the labor court. So these are the list of documents which seems to have been submitted. Regarding the allegation number 3, that notices were never issued. All these are the notices, if possible. 23 employees, multiple times notices were issued to them. But I'm not placing heavy reliance on that because it's not signed and I do not know whether this was actually that was filed in the labor court. But documents were submitted, they were exhibited, and all the findings in all the 3 charges have been documents not exhibited. The only ground taken is document not exhibited. So therefore, and if your lordship will also see our WS, that your lordship will find at page 18. Page 18. If your lordship will just come to page 20. Yes, sir. Paragraph 12, 13, and 14 are averments where we have stated that we had issued the notices to them. This is basically to meet the third allegation of disobedience or willful disobedience in view of not accepting the notices of the management. So basically, this is my case, Lordship.
Yes.
See one thing, your lordship takes up the written statement. Now, whatever charge sheet or locals, no specific date, nothing. If your lordship takes up this paragraph 12, 13 and 14, it speaks about certain inquiry notices. Now, what was the charge sheet dated? What was the reply? Nothing has been specifically pleaded in the written statement. And the written statement, which is annexed at page 22, lordship will not find the name of the manager who has taken the responsibility to verify the written statement. And the affidavit in the writ petition was shown by the director, and we do not know. And how the director can verify the affidavit saying that the statements made in paragraph 13 is true to is not.
Mr. Chakraborty, the question in these circumstances, extraordinary circumstances, we can only ask you whether you had filed an affidavit
Me. Of course, my lord, lordship is
in this
aware,
proceeding.
lordship is aware normally.
Because see, the records are not there. Maybe whose fault we not know. So he is relying upon the pleadings made in the writ petition. Normally, for a deliberate court matter, we would not have the last person to see the pleadings in a writ proceeding.
In fact,
We are going by the records.
in
Now, in
fact,
absence of records, he has a specific statement in 3 paragraphs regarding some numbers of documents. And there's a labor court's finding that no documents were agreed. So the best defense of you would have been to file an affidavit denying. There is no affidavit.
now, my lord, why this affidavit was not filed? When normally in a challenge to an award, my lord, we go by the award, records of the award.
Now, when this writ petition is structured on a factual position that there has been a misreading.
In
That-
fact, my lord, the petitioner is saying that they have examined 2 witnesses, whereas the award says only 1 witness. Then which one to be believed, man? They
So
are saying
that is the reason an affidavit was required from you.
that time when the writ was filed, my lord, we did not conceive that the record will be misplaced. Anyway, my lord, I am handicapped, I cannot.
That is it.
We go by the normal process and practice. In a challenge to an award, no affidavit can improve the record. So no affidavit in fact is filed. Denying the award.
So under this present special circumstance, we are looking for, otherwise we don't look for affidavit.
I
We
appreciate
don't look to the repetition.
this special circumstances was also not known to us that records will be misplaced and our affidavit will be material to rebut. But fact remains, my lord,
But you did not come up for 17B also.
my lord, be honest, my lord, I was just.
No,
Counsel, my lord.
Understood, but 2010 to 2016, that's 16 years have passed.
You will see the list of advocates, my lord. I was just.
No, understood.
So I did not have any independent role here. Now, whatever it is, my lord, their pleading is in the writ petition that 2 witnesses were examined and the labor court says, in fact, my lord, labor court has made a categorical finding, it is only 1 witness. Lordship may come to page 30. Thereafter,
Where have they stated that there are 2 witnesses?
I do not know.
No,
That-
from where?
That may be a typographical error. I have
No,
said
no.
MW1 has exhibited 462 documents. And the second line is the MW2 was exhibited the attendance register. It is
Paragraph 13.
MW1.
No, it cannot be now, my.
No.
Now, he is relying on paragraph 13 of the writ petition at page number 10.
Yes, I have said MW1 has exhibited 462 documents. No,
Okay,
it's just
file
because of-
NH1 है.
Oh.
Point लिखी नहीं
No files one है.
है. Now, Lordship will see, MW1 has not submitted and exhibited the labor code, the findings of the labor code that MW1 has not submitted and exhibited any documents to substantiate that the notices were issued to them. And that same was not accepted by the workmen is absolutely worthless and not based on materials. In fact, MW1 has exhibited 462 documents. In fact, my lord, we do not know what are the documents, including the envelope which were returned to the management. The MW2 was exhibited the attendance register to show the continuous absence of the word. So here is a categorical statement that 2 witnesses were examined, MW1 and MW2. And the labor court has made a categorical finding that it is only 1 witness. Lordship may have a look at page 30. Thereafter, desired by the management, both sides were asked to adduce evidence on merit. Accordingly, the management examined one witness, while the workmen side examined three. Now, if we are to rely and proceed on the basis of the statement made in paragraph 13, then we'll also have to see how far it is correct. When there is no MW2, when it says that MW2 was examined. And my lord, the charges, my lord, if your lordship takes up the charge number,
No, Mr. Chakraborty, we may not go to the charges. We are exercising certiorari jurisdiction. We will only go to the aspect whether the relevant materials were taken into consideration or not. Labor Code has come to a finding there are no materials.
no material.
No materials. And that is the exact point of challenge, that there were in fact materials 462 numbers of documents which were somehow not considered.
So for the charge regarding allegation number 2, my lord, the charge is that they are occupying and they have destroyed the topography and all. And now Labor Court has recorded a categoric finding that to maintain, first of all, lordship, if the employee occupies garden
Land.
land, then it can give rise to a civil suit. Will it by itself be a misconduct? Number one, ma'am. And number two, even if it is constituted to be a misconduct, whether the management could at least justify that this is the land which belongs to them. Labor Court has categorically submitted, come to a conclusion that management has not submitted and exhibited any document in this case to substantiate his claim that the said land belonged to the tea estate. Paragraph 32, page 32. So if you are bringing an allegation that someone has encroached upon my land and changed the topography, first of all, whether it will be a misconduct by itself or not is one question. And second, it is a finding of fact by the Labor Court that you have not established your title over that land. So it is not their case that we have submitted everything. And at least, my lord, they should have indicated in the writ petition what are the documents. Their statement is also very vague. And my lord, these are poor laborers, my lord, the records are not there, most of them died, and what remains, my lord, some financial benefit will be, at best they will be entitled to. Otherwise, my lord, I do not know, most of them might have attained the age of superannuation. So,
Okay, let us, whatever is possible, we'll do. Yes.
and lordship will also report that the manager is not the one who has shown this affidavit. So that is why the director could not have verified it. Lordship has at least examined the verification of the
Mr. Chakraborty, these averments of yours are strictly on the facts, without there being an affidavit. Questioning the competence, questioning the competence of, questioning the competence of the director, really difficult.
No, my lord, I'm once again.
We would have
submitting
still held against Mr. Sharma if the verification is not proper. Verification is done.
Director is saying that the paragraph, paragraph 13 is true to his knowledge.
Yes,
And the
but-
director was not examined in the inquiry.
He can still know.
Can.
Is it impossible? When he says on oath that it's true to his knowledge, you should have said, no, he was not there. He was at Calcutta.
So, in fact, my lord, the written statement also, the name of the garden manager is not there. Anyway, my lord,
Okay,
the whole
okay.
problem lies, we did not think at that time that the records will be misplaced. That is why we did not controvert the pleadings.
Okay.
In the matter of 2010, my lord.
Please have a seat. An award dated 19/8/2008 passed by the Learned Labor Code. Please have your seat.
Yes.
Learned Labor Code, Dibrugarh, is the subject matter of challenge in this petition instituted under Article 226 of the Constitution of India. Posted by the impugned award, the issues framed in the reference have been answered in favor of the workmen and against the management. Full stop. Para. The facts in brief are that a reference was made to the learned labor court on the following issues. Issue quote kar dijiye, huh? Page 26. The same was contested by the parties by filing written statement. Full stop. The management, who is the petitioner in this writ petition, has contended that to bring home the charges, there was a domestic inquiry. Full stop. However, the learned labor court had examined the aspect of fairness of the domestic inquiry and decided against the management. Full stop. Under those conditions, comma, the management had deduced evidence on merits regarding the three numbers of charges. Full stop. In gist, comma, the three charges pertained to unauthorized absence, comma, encroachment of the land of the management, and insubordination as the notices were refused to be accepted. Full stop. It is also contended that the charges were proved before the learned labor court by a management witness, and as many as 462 numbers of documents were exhibited. Full stop. However, the learned labor court had come to a finding that no documentary evidence were there, and accordingly, the charges were held to be not proved, and the reference accordingly answered. Full stop. Para. I have heard Sri A. Sharma, learned counsel for the petitioner. I have also heard Sri S. Chakraborty, learned counsel for the workman. Full stop. Para. At the outset, it is to be mentioned that the records of the learned labor court, which were called for by this court, have remained untraced in spite of number of attempts. Full stop. Even orders for reconstruction of the records were passed, could not help the matter as no papers could be retrieved. Full stop. Further, Sri Chakraborty, the learned counsel for the respondent, has also expressed his predicament as there was no contact with the client, as the leading counsel he's not in the profession. He's not in the profession. Now,
Leading counsel.
leading counsel is not in the profession. FT member, I think. Orchard. No, not in touch with the clients. For para. Be that as it may, comma, considering that this matter is pending since the year 2010, comma, this court did not deem it fit to further adjourn the matter, as it would be against the interest of justice. Para. Shri Sharma, the learned counsel for, please have your seat. The learned counsel for the petitioner has submitted that the findings arrived at by the learned labor court is unreasonable and unfair, as there is a wrong, there is a wrong observation that no documents were exhibited. Full stop. In this regard, comma, he has drawn the attention of this court to the pleadings made in paragraph 13, 14, and 16 of the writ petition, which read as follows. 13, 14, 15, quote kar dijiye. He has submitted that there is a specific pleading that as many as 462 number of documents were exhibited, which, however, does not find place in the impugned award dated 19/8/2008. Full stop. He has submitted that the management could discharge its burden by proving the allegations, and only on the ground that the workman's witness was not cross-examined, comma, the findings, impugned findings have been arrived at, full stop. He has also submitted that in absence of the original records, comma, he would depend on the pleadings which have been duly verified, full stop. He has also placed before this court a list of the documents which was retained by the learned counsel who had conducted the case before the learned labor court, full stop. He has, however, fairly submitted that the said list is a personal copy without there being any certification, full stop. He has also drawn the attention of this court to the written statement of the management wherein there are averments that notices were indeed issued and there was a refusal to accept the same, full stop. Para. Sri S. Chakraborty, the learned counsel for the respondent, has, however, submitted that the projection made in the writ petition does not appear to be the correct picture, full stop. He has submitted that in the written statement, there was no specific mention of any documents, and it is only in the writ petition an improvement was thought to be made by citing that 462 documents were indeed exhibited before the learned labor court, full stop. He has also gone to the merits of the allegation by submitting that the said allegation would not constitute a misconduct of such gravity which would warrant a termination from service, full stop. He has submitted that in absence of the records, comma, this court may deem the observations made by the learned labor court to be correct and the impugned award be upheld.
If your lordship allows me to discuss one thing which has come to my notice, if your lordship takes a paragraph, page number 24, written statement of the union, it shows that there is a pending reference and these workmen were connected. So that was the case specifically that subsequent dismissal was taken without the approval or permission. So,
Is it dealt with?
my lord,
Is it dealt with?
it is not dealt with. However, this particular pleading finds mention in the award.
That has been, it has been dealt with or what? Dealt with?
It has not been answered.
Oh.
Lordship may have a look at.
Okay. He has also,
It has come to my.
he has also pointed out that in the written statement, a specific pleading was taken on behalf of the workmen that there was an earlier reference pending and during the pendency of the same, the impugned action was taken. And this part has not been properly answered by the learned labor court. Para?
Amounts to my lord violation of section.
The rival contentions have been duly considered and the materials placed before this court have been duly examined. Full stop. Para. As noted above, comma, though the records of the learned labor court were called for by this court while admitting this case on 3/3/2010, comma, the records have been misplaced and remains untraceable, full stop. Under those circumstances, comma, though it would be necessary for this court to examine the materials on record, including the pleadings in the writ petition, full stop. It is, however, required to be mentioned that the respondents have not filed any affidavit in opposition denying the pleadings of the petitioner in this case, full stop. Para. There is a specific pleading in paragraphs 13, 14, and 16 of the writ petition, which have been extracted above, that there were 462 number of documents exhibited which were not considered, full stop. As noted above, comma, there is no denial to the said pleadings, full stop. This court in exercise of writ jurisdiction would only be concerned with the decision-making process, full stop. In other words, comma, this court would look into the aspect as to whether the relevant factors have been taken into consideration or as to whether extraneous or irrelevant factors have been taken into consideration. Full stop, para. It is the specific case of the management petitioner that 462 number of documents were exhibited which do not find mention in the impugned award dated 19/8/2008. Full stop. The aforesaid awardment being not denied, comma, this court do not have any other option but to proceed with the materials before this court. Full stop. There is also a reference in the written statement of the management that notices were issued which were refused to be accepted. First of all, under those circumstances, comma, this court is of the view that the principles laid down by the Honorable Supreme Court in the case of Nasim Bano ... will be squarely applicable. Full stop. Though Sri Chakraborty, the learned counsel for the petitioner, had attempted to argue on the merits of the case that the order of termination was not proper at all and the award is justified, comma, this court is of the view that in exercise of certiorari jurisdiction, comma, this court would not enter into the merits of the case, more so when all the materials are not available before this court. Full stop. This court has also taken note of the fact that while admitting this case, while order dated 3/3/2010, there was an order of stay of the impugned award dated 19/8/2008 until date, comma, not to talk about any affidavit in opposition, comma, even an application for vacating of stay or for invoking the section 17B of the Industrial Disputes Act 1947 has been filed. Para. Under those peculiar facts and circumstances, comma, this court has no other option but to interfere with the impugned award dated 19/8/2008. Full stop. The impugned award dated so and so, passed by the London Labour Court in so and so case is accordingly interfered with and set aside. Full stop. The records, if any, be sent back to the learned tribunal, learned Labour Court.
Obliged, Your Honor.
Please you take that.
Yes, sir.
Or you can give a copy of this.
Yes, sir. It can be kept, Lordship.
We express our gratitude to you for assisting. Okay.
Obliged, Your Lordship.
Lordship, kindly pass over the matter for a time being.
10 and 11.
Yes, Lordship.
Here for whom? SP Das.
Petitioner, yes, Lordship. He is at
Other side?
Lordship, he also informed that he is at code number 1.
Okay. Yes, Mr. Nath. 11:30 he said. What does that mean? In Nasim Bano condition 94, supply one. Item?
Last week I have taken time to file affidavit reply, but the affidavit reply may not be required, only suitability, my technical bid was rejected, otherwise.
Ready, other side ready. Mr. Bharadwaj is on legs, Mr. Sharma is on legs. What will happen to the cases?
But it will be taken up day after tomorrow.
Day after tomorrow, we have already fixed 2-3 matters. Those will take time. How long will you take, Mr. Bothago?
It will not take time.
What is the issue?
Yes.
What is the issue?
No, issue is my technical bid was rejected, as because my peso license is not valid, as per their condition.
What was not there? Invalid?
The peso license,
What license?
My peso license,
What is it? What?
Petroleum and explosive license,
You do not have a valid peso license.
For my understanding, it's a valid, Earlier it was.
Your understanding will not do whether it's a valid or not valid. These are objective satisfaction.
Yes, madam.
Why, as per your understanding, it is a valid
Because my
license?
lord, I have taken the vehicle, my lord, which was in others name, my lord.
Other's name.
Others name, the person who has the vehicle, my lord, he has the valid license, my lord. After that, it was transferred to me, my lord. So the period, my lord, that was valid, my lord.
Somebody indeed had a valid transfer license,
Yes,
but it was not transferred to you.
yes, well, later it was transferred to me, my lord. The period of my lord, validity is within the period, my lord.
It is done by draw of lots, what, petrol pump or what?
No, my lord, it's a
Vehicles.
yes, my lord. Vehicles, my lord.
Okay, we can try day after tomorrow, let us see.
Yes,
Day after tomorrow, okay? Heard Sri S. Bhotakur learned counsel for the petitioner. However, a prayer for adjournment has been made on behalf of Sri M. Sharma, learned standing counsel, IOCL. Para, in view of the above, matter is adjourned to be listed on Thursday. Date दीजिए.
Thirteen, 14 and 15 are together, madam. This is the matter where we had initiated blacklisting proceedings, issued a show cause. That has been put to challenge. Your lordship granted us the liberty to proceed with the inquiry, but not to pass final orders without your lordship's leave.
There is an IA also, Mr. Chaudhary.
We have filed for seeking leave of your lordship to pass final orders. What has happened is, some of these people.
Yes, madam.
Lordship, I'm sorry, Lordship, we have filed our objection today itself, Lordship. So Lordship may take up the matter for disposal on Friday, if not.
Have you given copy?
Yes, Lordship, I have just served the copy, but that is not record, Lordship.
Difficulty is one of some of these persons against whom inquiries are going on. They have also participated in the fresh tender process. Now, in case there is any adverse, and we have held.
Friday.
Yes,
But Friday anti-matter.
Entire.
Oh.
yes, yes.
Okay, not the IA. Will
Entire.
not be confined to the IA, okay? Heard. Who's there? Mr. Harshri A.K. Gupta, learned counsel for the petitioner, A.K. Gupta, comma, M. Nirola, and you also Mishra. All three different matters. For the petitioners in these cases. Full stop. Also heard Sri I. Chaudhary, learned senior counsel, assisted by Sri P. Barua for the ONGC. Full stop. The senior counsel for the respondent corporation has also submitted that IA 2626 of 2026. No, IAs have been filed for seeking leave of the court. Full stop. The learned counsel for the petitioner has, however, informed this court that an objection has been filed today, which, however, has not been tagged with the records. Full stop. Para. Since urgency has been expressed by the learned senior counsel for the corporation, respondent corporation, comma, list these cases for consideration on Friday. The objection filed is to be tagged with the records.
Your lordship may make an observation that an endeavor will be
Oh,
made to disclose.
we'll remember, don't worry.
Lordship, in item number 14, interim order may continue.
Interim order, if any, stands extended till the next date of listing.
Obliged.
एक ही order होगा. But Friday, don't seek time.
Similar manner with 13 and 14.
15.
Similar manner.
Similar. 15. Entire. इन्हीं का भी नाम लिखा ना, मिश्रा भी लिखा ना ऊपर. 10, 40, 15. Mr. Nath.
The order is not downloaded. In fact, yesterday I have indicated before the honorable court that today is the last day and another matter is pending here. Possibly, the lordship takes up.
Today is the last date. If we decide in his favor, he will not have the fruits of the litigation. If we decide against him, matter will be different, but we cannot speculate.
In fact, this is the status. The conditions which the petitioner had challenged, that.
Those have been set aside. Now, will he be able to apply?
Petitioner cannot.
So that's my problem. That is why I filed it.
Because the honorable court has said that as they interpreted clause 7(1) and 2(z) of the targeted public distribution order 2015, under which NFSA rice has been distributed. The tier 1 and tier 2 is implemented. That allows only the cooperative societies and the GPSs and all to take part in the test.
MSME cannot.
Private parties cannot. Here the petitioner is a private firm. The firm cannot.
So, but if he has got a registration under the MSME,
Registration under MSME, it's a private firm. MSME is, of course, it is not an issue there. But honorable court said that.
it's only for cooperative societies.
Because they.
So there is no question of having a separate slab for a corporation. If the entire clause goes, it is only meant for the GPSs.
Well, the under targeted public distribution order of 2015, an authorized agency has to export these rice. So authorized agency, lordship has interpreted that authorized agency, the cooperative society or the GPSs, they are the authorized agency under 2(z), not authorized.
Then Mr. Sharma, it will be difficult.
No, my lord, lordship will give me 5 minutes time, lordship. What my learned friend has said, subject to correction, my lord.
Now we
It is
are
not
also
like this.
handicapped. We are also handicapped because we wanted to have a.
Lordship will not agree with
That
the
is the-
coordinate bench event. It is I'll satisfy your lordship.
That is the status shown in the website about the petition. The status is shown as disposed of, but the order is not.
What is the last time of submission of bids? It's online, isn't
Today.
it?
Today.
No, date we know. Last time.
I mean. 5 p.m.
5 PM.
5 p.m.
It's online bid, isn't it? Online,
E10.
e-tender.
E10.
Lordship will give me 5 minutes, lordship. Lordship, I'll satisfy. Lordship, may please come to the tender page at page 35. Lordship will take note,
35.
page 35. My lord, my learned friend has appeared in all the cases, so it is subject to correction. My lord, I'll place the matter before lordship. Lordship will consider if I'm wrong or
35.
page 35.
Yes, please.
The annexer D. It is a e-tender document for handling and transport of contract for implementation of the doorstep delivery of food grains to GPSs, WCCS and FP shop dealers. So it is implementation of doorstep delivery of food grains to GPSs and handling and transport contract, lordship. Lordship will take note. It's handling. Lordship will take note of 2 words. It is handling and transportation. Lordship will take note. Now, lordship, my learned friend has said that the coordinate bands has please come to page 38.
Yes.
My learned friend said that the coordinate bands has said that the qualification criteria for bidders the 1 and 3, 1 and 2,
2 and 3.
2 and 3. 2 and 3 said no, it is, so it is set aside. Now,
And I've been made ineligible.
now, lordship may please come to page 39.
$39.
Now, while doing this, at the coordinate bench has also said, now the GPSs and the WCGS is the only no other private contractor in join. That's what my learned friend has said, that I got that, right? That cannot be, lordship, because that is what I want to satisfy this call. Lordship, now please come to 6.
Yes.
The bidder should have valid labor registration and so
and the Resident Labor Commissioner certificate to upload, update EPF Sana. In case of GPSS and so the tender bid evaluation committee will justify. So there a handle is given to tender committee for the GPSS and the WCCS, they will justify. Now 7, 8. The bidder shall have to upload the copy of the solvency certificate not less than 35 lakh from the nationalized bank. So now Lordship me 9.
Yes.
But
can I just give the, I'm sorry, Mark, can I make a submission? Can I come at 2 minutes?
No,
That
in
is
the
what-
meantime, let me
that-
satisfy your Lordship.
That is why we are asking what is the last time?
Till 5.
5 o'clock.
No, let me,
If it comes, okay, if it not comes, I'll.
2 o'clock Lordship will decide. Let me place my case. My case is not that what the coordinate bands has said. That is not my case. So Lordship, these clauses are there, the 9, then 13, all these clauses are there. Now Lordship may please come to page 47. Page 47, serial number 4. Page 47. For the technical bit, it is the annexure 3 of the tender document.
Yes.
Composition of bidder and registration detail state whether the bidder is a proprietorship concern or registered partnership firm or a company or a registered cooperative society. The name of the proprietor, all partners, the director of the company, secretary of the cooperative society as applicable should be given. What is this, Lordship? Proprietor. So Lordship, the 4 has given that it is a proprietorship firm, you say that. If it is a partnership firm, you say that. Anybody. There is no bar. So now, Lordship. Now, Lordship, please come back to page 40. Page 40. So this is the instruction for the submit tender at page 40. I'm not reading all this, but this instruction, there is no bar. All these, Lordship, I will not read. All these, there is no bar. My learned friend will reply, Lordship, what I said, if it is wrong, my learned friend will reply.
In fact,
This,
Honorable Court has directed us to issue a corrigendum and go ahead. After setting aside, Honorable Court has directed us to issue a corrigendum and go ahead. Possibly-
okay, that also will satisfy this court.
Possible.
That also will satisfy this court.
How can you?
Then you cannot. I'll satisfy.
But Mr. Sharma, okay, this order has not been uploaded. But your proper forum would be either you file for a review because you'll be affected by this judgment, or you may take leave and file an appeal.
I do not have that. I do not have to go there. I'll satisfy Lordship. There is a division, 2 division bench judgment of this court. 2 division bench judgment.
Regarding
the same matter, Lordship.
let us see.
Yes, I'll show one by one, Lordship. Lordship, because all these coordinate bands is referring to one judgment only. Lordship,
Kindly place the DB judgment.
I'll place the DB judgment, Lordship. Before that, Lordship, why all these coordinate band is referring to one judgment, that is 2017, 5 GLT, page 222. My learned friend will agree to that. This Lahwal Samabhai Samiti versus Teto Basam.
This is before the.
Yes, Suman sir. So, all these coordinate bands is referring to this? Yes. Yes.
This is now before the DB.
Now, Lordship, against this judgment, it is pending before the division bench. And Lordship, this is a judgment where what is the point?
In my favor.
It is in my favor. It is the same paragraph, so it is the Lordship may please come to para 2. Para 2. Because Lordship to know what is the core question. The core question that arises for decision in this group of writ petition is whether or not the decision of the state government to engage private parties as transporters for transportation of the PDS article for doorstep delivery of the fair price shop is in consonance with the Targeted Public Distribution System Control Order 2015 issued under Section 3 of the Essential Commodities Act 1955. So this is the core question before the court. Now, Lordship, I will not read all these facts. Directly, Lordship may please come to para 15. It's a well-written judgment, Lordship, long judgment. And Lordship, now please come to para 15. Page 4.
Parliament.
Yes. The Parliament has enacted the National Food Security Act 2013 with the object of providing food and nutritional security in human life cycle approach by ensuring access to adequate quantity of quality food at affordable price to the people to lead a life with dignity and for dealing with the other matters incidental thereto. The Act of 2013 is the outcome not only of the state's obligation under Article 47 of the Constitution to provide rising level of nutrition and standard of living of its people, but also the commitment of India towards the implementation of the Universal Declaration of Human Rights and International Covenant of Economic, Social and Cultural Rights, to which the India is signatory. The declaration casts a responsibility on all state parties to recognize the right of everyone to adequate food. A bare reading of the statement of object and reason of the Act 2013 goes to show that the paramount object of the Act is to provide nutritional security to the poor by implementing the targeted public distribution system by making available subsidized food grains to the people living below the poverty line, including so-and-so Yojana and also the above poverty line household. From the scheme of the NFSA 2013, it is apparent that what was considered as a mere welfare measure for the poor in the country has now been given the shape of legal right under NFSA 2013, ensuring food security to all the eligible beneficiaries. The NFSA contains specific provision laying down the specific role and responsibilities of the central government. Lordship, Mary.
Yes, yes.
Central government, state government and the local authorities. The section 22 of the Act 2013 inter alia provides that the central government shall be duty bound to allocate the required quantity of food grain from central pool to state government. Now, the section 24 is quoted. I am reading this, Lordship. Section
What
20.
is the answer
Yes,
of this
yes,
court?
yes.
Please.
That I'll go, Lordship. Lordship, may before that,
Para 21.
para 21. Because Lordship will get that then.
Para 21, 24, 25, then 26.
Para 21, Lordship.
You have read 21. What is the, how is the question answered by this court?
Yes.
Whether it can be done by private?
Lordship, may please come to para 24.
24 and 25 is what has been relied upon later, but the rest of the judgment.
Because the all other, the coordinate bench judgment, this 24 and 25 is quoted. I'll read, Lordship.
But the later part.
So, Lordship, this 24 and 25, Lordship will read. Now, this petition is dismissed by that court. That Lordship you have to look into. And then actual decision is in the para 25 only.
27.
27 onward.
24,
24 and 25. I'm reading, Lordship. because all other coordinate bands has quoted this 24 and 25. It is not doubt true. It is no doubt true that the clause 2G of the order 2020 does not envisage any private party in the matter.
Okay,
of
we have read
lifting of-
this, we have read this. This court has upheld the idea that private parties can also be engaged for distribution and transportation of food
Yes.
grains.
Yes, yes. Now, Lordship, this is challenge. Now what happened? This court has said that. Now this is challenge before the division bench. Lordship, may please take this, division bench.
Till date, this is pending.
Till that this is pending, Lordship. No affidavit file, nothing.
Union has filed.
Union has taken time to file an affidavit on the last day. Lordship, may please come to order dated 3/9/2018
Right.
at page 5, Lordship.
This is the first one.
Just a minute, please.
Page 5. Order dated 3/9/2018. Lordship, get it? Having regard to the facts and circumstances of the case, also considering the fact that the appellants are continuing and distributing the food grains from the so and so, we direct the parties to maintain status quo, no stay order. Lordship, the single judge order is not stayed.
Why the problem is that?
Lordship, get the point? Single judge order is not stayed. Division bench state maintains status quo. These people are supplying. So maintain status quo.
In my case, I am supplying.
In my case, Lordship, may please come to my page directly because I have annexed that. I know that Lordship will ask me that question. Page 27. Page 27.
Of,
Page 27 of my read. Annexer C.
Every month, I get something like this.
yes.
Lordship, get it? This is the last. So I have annexed. All the orders I have not annexed. This is the last one. 18/7/2026.
For the
Lordship, get it?
Yes.
And my name is in the 5th line. The transporters are so and so versus Payman Ahmed. 5th line, Lordship, it is in bold.
page-
Lordship, get it?
Page 30
Yes.
was-
That is, my name is, the petitioner's name is there in the 5th line.
Page 30 was.
Yes.
Then Lordship, may please come to page 30.
By Mana.
Yes.
Page 30, top. GPS says so and so under Payman Ahmed.
Problem with your live fully.
Why this problem started, Lordship? Lordship, may please come to WPC 1924 of 25.
This is where the problem is.
Now, Lordship, may take the, why the problem cropped up from this?
Justice Suman Sham's order is in my favor.
Because the Justice Suman Sam's order is my favor, Lordship. And division bench has not stayed that order. Division bench said maintain status quo. And accordingly, those people, they're running the private parties. And division bench, there is no application to vacate the order. Lordship, may please come to this WPC 1924. This is order dated 7/4/25.
Motion order.
It is in the motion itself,
Page 5
page 5.
is submitted.
Yes.
Lordship, it is submitted, third paragraph,
Hmm.
after third paragraph, Lordship. It is submitted by the learned senior counsel for the petitioner that the notice inviting tender itself is in violation of the 2G of the order and accordingly.
What they are saying.
Now, what is my learned friend argument is in my case? It is submitted by the learned senior counsel petitioner that the notice inviting tender itself is in violation of the 2G of the order and accordingly, there is no scope for the respondent authority to initiate NIT for inviting private contractor for lifting the food drain. It is submitted that this issue is pending before the writ appellate court in writ appeal number 240 of 2018, 297/2018, 12 of 2018, 249 of 2018, and the status quo order has been granted in this matter. Pursuant thereto, several writ petitions have been filed, wherein, while issuing notice, the coordinate branch has stayed the NIT. The learned counsel for the petitioner prays for the similar order. Now, accordingly, while issuing notice, making a returnable after 4 weeks, let the notice inviting tender dated so and so be not acted upon till the next returnable date.
DC then engage the private contractor.
Now, this order is passed. Now, the deputy commissioner Tinshukia, he has sent a private contractor, then go and file an application.
Temporarily কাম কৰিব দিছিল তাতে।
And he has given an order that you do this work. He has given an order.
So
The deputy commissioner.
IA for direction.
So in the same case, against that order of the Tinshukia deputy commissioner, the writ petitioner filed a IA. Now this IA lawsuit will take, this order is 7/8/2005, 2025.
This order has created a dichotomy.
This order has created the whole year. Now, Lordship may, I will not read the everything. My learned friend know the fact, everything, because he appeared there. So,
There are 19.
Lordship, this order, Lordship can see at page 5, the order, Honorable Justice. It is learned single judge has passed. It is order dated 7/8/25. Now, Lordship may come to para 4
Facts.
at page 5. Page 5.
Yes.
Para 4. The contention raised by the applicant, because this is a miscase lawsuit. The contention raised by the applicant as petitioner in the writ petition was that the engagement of a private contractor for transportation of food grain, in contrary to the provisions of the targeted public distribution system control 2015, hereinafter referred to as order of 2015, more particularly paragraph 7(1) thereof, read with paragraph 2G of the order 2015. A coordinate bench of this court on considering the issue arising in the matter Vice 7/4/25, Lordship has already read, while issuing notice was pleased to direct that the notice inviting tender dated so and so be not acted upon till the next returnable date. Now, para 6. For the purpose of passing the said interim direction, this court has noted the submission of the learned senior counsel for the petitioner to the effect that the notice inviting tender itself was issued in violation of the paragraph 2G of the order of 2015. The applicant have thereafter instituted the present interlocutory application, inter alia containing that the District Commissioner Tinshukia, in pursuance of the interim order passed in the connected writ petition, has engaged a private transporter for transportation of the food grain from the godown of the Food Corporation of India.
Page 12.
Now, Lordship, may please come to page 12.
Operative direction. Ratio.
May I start it from page 11, Lordship? Then Lordship will get the whole thing. Page 11, paragraph 19. At the outset, it is noted that the present order is being passed in connection with the grievance raised by the present interlocutory application. The petitioner applicant has noticed herein above is by raising grievance in the regard to violation of the provisional order of 2015, had approached this court by way of connected writ petition assailing the notice inviting tender dated so and so. The grievance of the applicant, as can be called out by submission of so and so, for the applicants as well as the pleading brought on record, is to the effect that the provisions of paragraph 7(1) of order of 2015 mandate that the government shall leave food grains from the designated depot of the corporation through its authorized agency, and such transportation would be permissible to be made by an authorized agency of the state government concerned. So, now Lordship, this authorized agency, this para 20. The term authorized agency has been defined by paragraph 2G of the said order of 2015 to mean concerned department of the state government or a body corporate or a company owned by it or a cooperative society. It is to be noted that order of 2015 was so formulated by invoking the provisions of section 3 of the Essential Commodity Act 1955. The order of 2015, more particularly paragraph 7(1).
711 no control.
Lordship, it is 7(1) only.
711 is not considered.
So Lordship, for my case, Lordship will take note. I am in 711,
Not 7-1.
not 7(1). Lordship have to consider 711, not 7(1).
7-1 is
He has considered 7(1) only.
that is lifting.
Lordship will take note of that. I'll satisfy your Lordship. Why?
Where is that order of 2015?
Yes. Last time given a copy.
I have given a copy on the last date. Lordship, if not, I'll give again.
Court order and that service order copy has been given.
I have given a copy on the last date also. Lordship.
Yesterday.
Yesterday I have given.
No.
The court order is going to be in the other matter while issuing.
No. I have given the order there.
Service order.
Control order.
Control order.
Yesterday we given.
order. This order has come, this one.
No. That is
No,
the first
control order,
That is the
mine.
first order.
No, that is okay.
That is the first order where the issue has been noted. And fixing the matter on 49. The 49 order is not.
Oh, 49 has not come. Oh.
That's if logic peruses the order, the issue has been noted. That will clear.
Just a minute.
Now, Lordship, this is 7(1) only.
Just a minute.
এখানে আসেনি কেউ? এখানে আছে? তুলে দে।
Mainly colorful.
কবুল না? কি করছে? কোনটো order? সেইটোৱে কৈ আছো মই। সেইটোতেই যাম মই।
This is the problem.
দিছা এখন? দিছে। আৰু কিবা লাগে যদি কৈ দিয়া। আৰু কিবা লাগে যদি কৈ দিয়া।
What a TPDS person, kind of good.
Okay, this has been answered, this issue which has been framed in paragraph 4.
On 40 it is answered.
order আছে। কোনটো order পিছন?
Isn't it?
12তে। এটা 12তে ইস্যুটি কিছু ইস্যু।
No,
But don't you think there will be a conflict of opinions?
Well, in fact, 7(1, the service order I have planned. The definition of agency other to Z and clause
That is not
7(1 has
relevant
been-
for 711.
that is discussed.
No, we are not on that. We are on the conflict of opinions.
Yes.
Yes.
If we go by the first judgment,
The
Yes.
Lahowal's order,
But in
Yes.
Lahowal's order has not debarred private parties from
Yes.
participation.
Yes, and that's my point.
Now-
Let him,
24 has been interpreted in WPC number 1924.
That is wrong.
2627 is not there.
2025.
26 and 27 is not.
There is a subsequent order that is 171125.
There is nothing in the road.
In 171125, ultimately
There is
court has
nothing
said
in this road.
that 1711 will not come. In fact, that was our argument. On behalf of state, we argued
1711 I have got, there is nothing lost.
on 17, in fact,
There is
on
nothing.
That is-
in fact, on 711, we have argued that private party should be allowed.
Yes, yes.
Our argument was rejected.
Oh, yes,
It was not rejected. That is the point.
it is not rejected. It is, nobody has rejected that. Till now. It is the government argument, my lord.
If there is a rejection, that is my point. That creates. a
That
conflict with the
is what
promotional.
the government argued on 1711. That is my point in this case. And Lordship, the problem is, Lordship, only 24, 25 is read.
1711 relies on this. 1711 relies on this order.
That is why I am reading this. No, this order has relied on the 1711 also.
Order 2 relies on these.
No, 1711 it will rely করছে। It will 782. 1711.
This is the basis of the 1711 order.
1711 is minor.
2, 6, 2, 4, 20, 26. Contractual.
Seventeen eleven order, Lordship can read para 10.
There is
What happened thereafter on 23?
So
23.
On 23, what had happened?
nothing.
Final order is.
Final order is 2-4, Lordship.
So matter has become infunctional.
Final order is 2-4. Lordship can see this.
On merit, there is nothing. On merit, the only order.
Hey, 2-4 on merit, there is nothing, Lordship.
Yes. Because in the meantime.
Operate. So
There is nothing. He said there is infectious.
in Lahwal, there is nothing.
In Laipuli,
Laipuli,
there is nothing.
except this order.
This 7-8, 2025 and 7-11, 2025. Lordship has directed us to not to act. So ultimately, accordingly,
This is correct.
District
Hey,
Commissioner-
he is correct now.
District Commissioner has allowed a cooperative society to.
That is the problem.
The matter become infractions and ultimately financial year also will come to an end.
My understanding is correct.
No,
That creates the
that-
contract.
In fact, we argued that under 7-11, state has a power to engage private contractor.
Yes.
That has been stopped.
Yes.
That has been stopped in by 7-8,
Yes. That is
25
my.
and 7-11, 25.
Right, he is correct, man. I am with my
That is
lordship.
the
So in that view of the matter, when there are conflict of opinions, first in the case of Lahwal, towards the last part, the resistance which was put to the court by the petitioners who were cooperative societies, that you cannot engage private players, that resistance was not accepted by the court. Court had dismissed the petitions and said that there will be no bar for the private players to participate. And that decision was been put to challenge at DB. DB says status quo. Status quo may mean either they participate, whoever is participating is participating. There is no final outcome till now. So under those circumstances, will it be proper to eliminate the participation?
But in fact, from state's point of view, Malad, we want broader participation. Therefore, clause 1, 2 and 3, we have incorporated.
No, we are not on your opinion. Your opinion, one side has been accepted by one of our coordinate bench. In other case, it has not been accepted.
Lordship,
So we are in a doldrum.
it is my duty to point out before your
Hmm.
lordship that same clause has been challenged. Lordship has passed on. And the issue has been filled as lordship has seen on 12/8/26.
But if those clauses are together set aside, then whether we can grant a relief to Mr. Sharma? We cannot say anything about, we can at best record our ability or inability to agree and send it, refer the matter for a larger consideration. But today is the last date.
But in fact,
If he succeeds, he'll be prejudiced.
in fact, practically speaking, ultimately, the order will come today. We will communicate, and in that order, Lordship has directed us to issue a corrigendum and go ahead. So ultimately, we have to extend, at least for 2-3 days, we have to extend. Because till now, we are awaiting the order. Although it is last day. I have telephonically communicated, but unable to provide them the order.
You do one thing, we'll try to balance. You do not finalize. We are not saying that if the last date goes, tomorrow if you hold them to be eligible, they'll miss the bus. So do not do not have the last date extended. In the meantime, we'll make some observation regarding the conflict and we'll request the larger bench to consider this. I think that is the only solution we have.
Lordship, because of the division bench judgment,
Okay.
Lordship can refer the matter and
Yes.
in the meantime status quo to be maintained, Lordship. He has the division bench has said.
It's not status quo. We can, we'll have this tender not to be, the last date to be extended.
Yes, yes,
Do not finalize.
yes.
Okay.
Lordship.
It is to be extended, Lordship. Then we can join.
Very shortly, because ultimately these are transportation of NFSA rights.
Yes.
Yes.
That
You
is
know
also important. I don't know what the solution there. I'll have to take instruction if Lordship directs us not to finalize the tender. But
No,
in fact,
not
I have
to-
to just talk to them.
Not
We
to-
can do one thing. You do not, we can have this matter for Monday or Tuesday also.
Oh, you.
Till that time, you do not finalize. In the meantime, we'll think over. Okay, heard 3.
Himandari?
May I-
Himandari.
Lordship may pick the matter on Friday.
Day after tomorrow.
Friday.
It is, okay, Friday we can have.
Today is Tuesday, Malak.
Friday, okay. Heard,
21.
okay, heard Sri S. Sharma, Learned Senior Counsel, assisted by Sri G. What do you write? A. Gautam. For the petitioner, full stop. Also heard Sri G. Nath, Learned Senior Advocate, Assam, full stop. When this matter was taken up for consideration yesterday, the Learned State Council had made a submission that in a matter where the same clause was involved, this court, a coordinate bench of this court has passed an order on 14/8/2026 interfering with those two clauses. Full stop. Para. The State Council has also submitted that certain corrigendum is in the process.
Honorable Court has directed. Still, we have not got the order. That has to be done.
The Learned State Council has submitted that there is a further direction from the court to issue corrigendum. And as the copy is yet to be made available, the Learned State Council is awaiting further instructions. Full stop. He, however, assures that we did that in view of the above, that instructions be obtained and the matter be taken up for consideration on Friday, full stop. To balance the equities, it is provided that the last date, which is stated to be last date for submission of bids, which is stated to be today, is required to be extended till the next date fixed, till Friday. Okay. If it is more than that, do know, at least till the next date fixed. I.e. Friday date to issue.
With Lordship, I have annexed that, so we are running the Lordship, that will continue, Lordship.
That we are not saying anything.
Yes.
We are only extending the last date so that it do not suffer prejudice in participating if we agree with you. Okay. Friday.
Running this, I'm grateful.
But you sort out the issue. You apprise the, perhaps what Mr. Sharma has clarified today, that was not put before this court, put before the coordinate bench. If, no, see, coordinate bench can take either this view or that view. but there has to be a reference to the original case, Lahwal case. Then you can express, have another view, but normally if we differ, we refer to a larger bench.
My learned friend tried, my lord, even his argument was quoted.
In fact, that was our argument, but honorable court did not accept. I'll place.
Okay, Friday.
I'm grateful.
But I pray that the copy of the order, if I can communicate to you.
Yes, this copy will have it within before lunch.
Good order, you will get by Friday.
The outstanding bill, in the meantime, budget has passed, some allocation has been made for budgetary election for today. This amount has not reached that people.
We had passed that the number was different. That case.
Similar order, my lord. To others, my lord, they have paid, my lord.
What is it, Mr.?
First is releasing it, another allocation is there, budgetary allocation is there, that fund has not come. When the fund come, it will be released, my lord. There are many persons here.
How much time do you require?
What's it after 4 weeks, my lord?
Okay. Heard Sri S.P. Das, learned counsel for the petitioner. Para. Also heard Sri S. Bora, learned counsel for the sole respondent. Full stop.
My lord.
Sri Bora, the learned counsel, has however informed that though budgetary allocation has been proposed, the funds are yet to be made available. Full stop. Though budgetary allocation has been proposed to comply the order of this court, the funds are not yet available. Full stop. He accordingly prays for some time to have further updated instructions. Para. In view of the above, matter is adjourned. Matters are adjourned. Both similar.
Yes, both similar.
Matters are adjourned to be listed on today's 18th. We'll have it on 23rd of September.
Sorry, my lord, I could not be
No
present
problem,
when the matter
no
was
problem.
called. My lord, a very short point is involved, my lord. Basically, we are against.
Mr. Gupta. Mr. Gupta is there.
Yes, Gupta is there. Matide. Technical gift he could say. मैं दूसरा मजा लगता हूँ मछली नहीं
Or we can have it at 2
At
o'clock.
2 o'clock, yes, ma'am. We'll also inform them.
He was there actually. We'll have it at 2 o'clock.
Yes.
You are for whom? Oh. Tomorrow, is it possible? Tomorrow? Day after tomorrow, I fix many matters. Day after tomorrow, we can take a chance, but we are not very sure. Tomorrow we'll try. Okay. Heard Sri K.N. Chaudhary, learned senior counsel for the petitioner. Also heard Sri H. Gupta, learned CGC, and Miss B. Talukdar, learned counsel for respondent number 4, full stop. On the request of Miss Talukdar. Mr. Gupta has come.
Yes, come.
Can you complete it in half an hour? Madam has some difficulty, some medical emergency. We'll have it tomorrow then.
Okay.
Tomorrow at 2 o'clock. Tomorrow. We'll give reference to this matter. Okay. On the request of Ms. Talukdar, the matter is adjourned to be listed tomorrow.
Deeply.
With an understanding at 2 o'clock, Mr.
Yes,
Chaudhary.
May it please, your lordship. Lord,
2016 matter.
exactly.
We have disposed of a 2010 matter today. So today is meant for old matters.
Old matters.
2010 matter disposed of with much difficulty. Records were not there.
Nonetheless, your lordship.
We have to.
Kindly pass over the matter. My senior is,
Who is your senior?
he went to the washroom, I feel.
Who is your senior?
I'm Talukdar.
Okay, he'll come.
Let him come in the meantime.
Hmm.
I'll just.
Okay.
Well, I'll take your lordships to the page 6. This is the judgment, my lord.
MSc appeal.
Well, page 6 or not.
Records are there. Upal. Records আছে? Records. Tak, tak. Tak, tak. Yes.
This claim case has been brought by the parents.
What
and
is the date? 10/4.
Dated, yes, 10/4/2013. Total award is, my lord, 3,36,000 plus interest.
For what? Injury case?
No, it's a
Death case?
death case.
Where you unnecessarily?
The assessment at that relevant period.
Why are you unnecessarily fighting this case?
No, my lord, this is
We'll
in
give a
fact
quietus in a
the-
decent manner.
the question of
We'll not say this will be a precedent. Somebody has died. 3 lakh.
my lord, whether the case is whether it is a murder simpliciter or it is
Murder case.
whether it is a murder simpliciter or whether it is accidental murder. There is a question involved. Now, what happened, my lord, this 2 or 3 passengers boarded the bus and then they murdered the driver and the handyman. The so-called handyman, we say that, it's all right, take your time.
Or murdered.
Now,
Not because of the use of a motor vehicle.
we say that it is not because of the use of the
There was no accident.
There was no accident. They entered in the bus and then killed both the driver and the handyman. And the court, the tribunal, they came to the finding relying on the decision of Rita Devi.
No,
That
Rita
is-
Devi is in a different context. Rita Devi is a Tripura case.
It's a Dimapur case. No?
Or Dimapur case. That's a different context.
It's a different context, but the analogy brought because that was an auto rickshaw. And
Auto rickshaw, what had happened? Terrorist had attacked.
yes.
Those are, these discussions are there, even in a bomb blast. But
In
here-
Dimapur case, my lord, what I understand, it could have been, my lord, maintainable if it was an horseman compensation. But then under the Motor Vehicle Act,
There is no accident here.
no
The
accident.
vehicle did not suffer anything.
No, no.
In that case, how do you maintain a claim in the MSCT? Mr. Talukdar? Otherwise, 3 lakhs, you are inclined to dismiss this, but not under these facts. There has to be an accident by the use of a motor vehicle.
Lordship,
This is not an accident.
Lordship, it is thoroughly explained in Rita Devi's case. Lordship.
Rita Devi, you have read and read number of times.
Lordship,
It is only to cover those circumstances where an accident happens not because of any negligence or otherwise. Suppose there is a bomb blast
Lordship,
in the bus. There is a terrorist cross-firing.
Lordship.
Somebody dies. Now, how do you tackle this situation?
Here,
Only on those an innovation was made that even the MSCT would be competent to give compensation. But here is a person has been murdered in the vehicle.
In section
Where is
one,
the case of MSCT? You can file for damage. If, of course, first a criminal case, then you can file a damage suit.
the wording in section 165 is very clear.
Lordship, in Rita Devi's case, these explains that murder, simpliciter, and accidental murder. In case of accidental murder, claimant is entitled.
Yes, is this an accidental murder?
Lordship.
This one.
Yes.
How come?
Miscreants took the vehicle, pretending themselves as passenger, and subsequently the miscreants killed him. Killed both the
No,
owner,
no, it'll
driver, and
be difficult. Difficult to.
that's paragraph 8, Lordship.
Have you made any payment?
50%, I think, paid.
50% do not recover.
My lord, 2026 SCC online. I'll just stand over to your lordship's paragraph 30 will cover this case.
First, we'll have to read Rita Debios.
Lordship, as you see the judgment of our Supreme Court in this case.
First, to have a better idea, let us read the impugned judgment, okay?
My lord, before reading it, can I take your lordship to section 165?
Motor Vehicles Act. Yes.
A state government may, by notification in the official gazette, constitute one or more motor accident claims tribunals, hereinafter chapter referred to as claim tribunal, for such area as may be specified in the notification for the purpose of adjudicating upon claims for compensation in respect of accidents involving the death of or bodily injury to persons arising, I am referring this, my lord, arising out of the use of motor vehicles.
Use of motor vehicles, that is
Yes.
the expression used,
That
use
is
of
the-
motor vehicle.
Yes.
That has been given a broad meaning in Rita
Yes. Well,
and explained only to cover those situations. We have
Exactly.
already explained.
now, my lord, let us come to the judgment, which is from page 6 onwards.
What is the citation of Rita Devi?
That is, my lord, give, 2006. My lord, I'll just hand over to you, lordship.
2000?
2000. Rita Devi. Decided on 27/4/2000.
That is what Manupatra.
Manupatra.
It is reported also.
Reported in all the judgments, my lord, I am having readily.
2005 SCC 113.
2005 SCC 113.
2000?
Volume 5 SCC.
Volume 5
SCC.
SCC 113.
113.
My lord.
Can you have a copy?
Your lordship may see paragraph 9 and 10. my lord. 9, your lordship may skip 10. my lord. The question therefore is, can a murder be an accident in any given case? There is no doubt that murder, as it is understood in the common parlance, is a felonious act where death is caused with intent and the perpetrators of that act normally have a motive against the victim for such killing. But there are also instances where murder can be by accident on a given set of facts. The differences between a murder which is not an accident and a murder which is an accident depends on the proximity of the cause of such murder. In our opinion, if the dominant intention of the act of felony is to kill any particular person, then such killing is not an accidental murder, but is a murder simpliciter. Well, if the cause of murder or act of murder was originally not intended and the same was caused in furtherance of any other felonious act, then such murder is an accidental murder. Now, whether the instant case come within the purview of this, your lordship will see.
Okay, yes. What was the vehicle involved? Public carrier.
Just is a
Ma-
truck.
Obviously, the handyman, it has to be a commercial vehicle.
And if your lordship look at the examination, cross-examination of CW1, she has stated that it is simply a case of murder. In the cross-examination, it has come up. Case relates to murder and has no relation with motor accident.
What is the meaning of the expression accidental murder?
Accidental murder, my lord, in order to, my lord, if the main intention is to take away the vehicle, and in the process, he was murdered. But there will have to be evidence, my lord, your lordship will have to see the new judgment, that is 2026. Their lordship has expressed, there will have to be some proven the statement of
You are referring to Dilip Agarwal.
Dilip Agarwal. If I
Have you read Dilip Agarwal? Please, because this will continue in the second half.
the
With
lordship,
2026 FCC online, we give the citation from Mr. Datta.
I'll give him. It's a bit improvement over the Rita Devi's case. Their lordship referred the Rita Devi also here.
But Rita Devi is on rereading this paragraph, which have also been considered by the learned tribunal. There appears to be some discussion regarding accidental murder.
Yes.
So whether he'll get benefit of that.
Accidental murder somehow is a sympathy and my lord, on the benefit of doubt it is given. But then strict adherence to the legal provisions, my lord.
Now, the expansion of the law done by the Honorable Supreme Court in Rita Devi, whether he will get the benefit. Initially, we are on the expressions used in the statute 165
Yes.
by the use of a motor vehicle.
Right.
Now, Rita Devi has slightly expanded, bringing the concept of accidental murder. What is the meaning of an accidental murder?
Now, the question would be, my lord,
Now, see, we have to see first that the intention. Is if the dominant intention is to murder, kill a person, then it is murder. Simply said. And for furtherance of such object, he was killed, then it is accidental murder.
these are, my lord, we are drawing only inferences. Now, when we draw inferences, my lord, there must be some evidence.
So
That
detail
is
was
what
taken away.
2026, my lord, their lordship has seen. And here, if your lordship scrutinize the
No,
evidence.
Mr. Talukdar, there would be circumstances. Suppose the vehicle was going and somebody shoots him with the intention to murder him.
That is purely murder.
No, shoots him, but he was driving. Now somebody alights in the way on the vehicle, pretending to be passengers,
Lordship,
then causes the murder.
lordship.
Will it come under
With a purpose
165?
To snatch away the vehicle, that is there. Vehicle was
No, to
snatched away.
snatch away the vehicle, will it still bring you under the ambit of 165? What you are submitting, let us accept it. Intention was to steal the vehicle
Steal the vehicle,
by committing murder.
lordship.
Now, will it amount to a case where you can be entitled to seek compensation under the MACT?
Lordship.
We will have to answer this. We'll answer. What is Dilip Agarwal? Which paragraph, Mr. Dutta?
Paragraph 13 and 14, my lord.
What are the cases which have been considered?
There are various decisions may referred. Your lordship will find that in paragraph 11, my lord.
Rita Devi has been discussed.
Yes, it has been discussed.
Which paragraph? 11.
Para 9, my lord.
No, the finding.
Finding 13 and 14, my lord.
We have the view. Please read.
We are of the view that even on this lighter standard, there is no causal link that has been established. A perusal of the judgments of the courts below, in a sense, assume that the injuries suffered by the deceased took place while Dilip and Anand were in the car. How such a conclusion came about is best known to them. The evidence on record does not point to any forensic proof having been recovered from the car, for example, blood, skin cells, hair, etc. Neither it is anybody's case that Dilip's car is involved in any collision. All that has said is that the injuries sustained by Anand were by hard and blunt objects. Now, true it is that the claimants need not establish the particular manner in which injuries have been sustained by the injured or the deceased, but that does not mean that simply because there was a car somehow involved in a chain of circumstances that led to his death. The provision of Motor Vehicle Act would apply. Some link whatsoever between the car and the death has to be established. Pursuant to the aforesaid discussion, there is an alleged accidental murder and there is a motor vehicle, but the relationship between the two specifically involving a motor vehicle
Okay,
has not been
okay, we'll
established.
come back at 2 o'clock. When we have fixed 5, Huh?
It was Passover for time being. Lord.
time being. What is it?
Today's reply has been filed today, Lord.
Who has filed?
Petitioner.
So when can we have this, Mr. Here for the respondent? When can we have this?
Next week.
Huh?
Next week.
Next week? Okay. I'll have 5 to. A rejoinder affidavit has been stated to be filed today by the petitioner, which however is not tagged with the records. Para? List, the matter accordingly stands adjourned to be listed on 25th. Next Tuesday, 25th. The affidavit said to have been filed, be tagged with the record.
Your lordship had put a query as to what is a accidental murder. Now, from the judgment which I have cited earlier, Dilip Agarwal, it has stated that there has to be a casual nexus between the accidental vehicle and the murder which has been caused in furtherance of use of that vehicle. So that proximate cause or casual nexus, that has to be established by the claimant. So that evidence that is not there in the present case, that is missing. The nexus between the accidental vehicle and the death leasing in furtherance of that vehicle. Now, your lordship, I would like to rely on another decision of this honorable court in National Insurance versus Kashani and others. There also
Is it reported?
is reported in 2005 3 GLT 465.
Name?
National Insurance Company
Versus?
Kashani and others. Kashani, Kasheni
Kashini.
and others.
Okay. Which paragraph? What is the
Uh,
proposition?
The paragraph relevant para is para 11. I'll read out the entire para.
Yes, please.
Having understood the law in the manner indicated above, we may now proceed to analyze the situation that the evidence and materials on record give rise to. If the case of the claimant respondent, as stated in the claim petition, is that her son was traveling in the auto rickshaw as a bona fide passenger, and that though the auto rickshaw was signaled to stop, the driver of the auto rickshaw did not pay any heed to the said signal and instead drove away at a high speed leading to the firing in question, the aforesaid facts should have been established by leading cogent evidence. The above requirement was imperative, keeping in mind the case of the insurer and the owner of the auto rickshaw as pleaded before the learned tribunal. That is, the deceased son of the claimant was being chased by some miscreants when he boarded the auto rickshaw, which was eventually overtaken, and the son of the claimant was shot dead by the miscreants. The basic facts giving rise to an entitlement for compensation must be proved by the claimant. However, liberally, the pleadings or the evidence may be construed by the court. In the present case, the only witness examined is the claimant herself. Claimant, unfortunately, is a blind person. What was narrated by her in her evidence is that her son died while he was traveling in an auto rickshaw. Beyond that, no details of the incident was deposed to. As against the evidence of the claimant, the insurer to prove the case pleaded and had examined two witnesses, out of whom the evidence of DW2 would be of significance. DW2 in his evidence had proved the report of investigation submitted by him and orally testified that the son of the claimant, on being chased by miscreants, had forcibly boarded the auto rickshaw, which was overtaken and burned down, and the son of the claimant was shot dead. While it is correct that there is room to doubt the veracity of DW2, as he had admitted in his evidence that his report of investigation as well as his oral testimony is based on examination of some persons, and that he had not examined the owner or the driver of the auto rickshaw, merely because the said evidence of DW2 is held by the court to be of doubtful nature, cannot be a ground to hold that the case of the claimant necessarily stands proved. In the present case, having regard to the basic facts in which liability to pay compensation had to be established, and particularly having regard to the facts in which the use of the motor vehicle was involved, it is our considered view that the claimant respondent ought to have led more positive evidence to prove that the death of her son had occurred in an incident arising out of use of the auto rickshaw. So, in this case also, there is no such evidence that the that the murder has occurred out of the use of the vehicle. Well, also, I'll hand over the copy.
Rita Devi was not discussed in this,
In the new judgment.
in this 2005 judgment.
2005 judgment, probably it has not been discussed. Fine, that's right. In the facts of the present case also, while the driver and the handyman was plying the vehicle, then these miscreants, they stopped the car, they entered. Then after some time, they killed these two persons and later the body was recovered. Now, nowhere from the record, it could be shown by the claimant that the deceased, they were killed due to the use of the vehicle, out of the use of the vehicle. Clear case is of of murder simpliciter. Because there is no nexus also. Linking the vehicle to the murder. And if your lordship goes to the PM report also,
You have enclosed to the appeal.
and it will be in the TCR, Exhibit 5.
What is there in the PM report?
The death was due to shock and hemorrhage resulting from cut injury over the neck, and injury was antemortem and caused by sharp cutting weapon and homicidal in nature. Now, nowhere it is in relation to use of this vehicle. Simply these two miscreants entered, they sat in the vehicle, they murdered
The
and
PM report may not be conclusive
Yes.
because even if a person dies in a boom blast,
homeless.
which has been implanted in a vehicle, he will not have the symptoms or the in the PM report. The findings will not lead to a finding that it was an accidental that appears to be from their use of from a road traffic accident. RTA will not be there.
Yes.
So that may not be conclusive, the findings in a
But there
PM.
the dominant intention will be different. That in case of a planting of bomb or something, the intention would be to instill fear among the crowd. Here, this is not a case. Here, the case is that these people hijacked the car, then they murdered, and then they left. And that is a case where of instilling fear among the crowd, or
If a death occurs by planting of a bomb in a moving bus, what will happen then?
then that in those circumstances, the insurance will obviously be liable.
So what would be the
Because-
difference in
Because
principles?
there the dominant intention is to instill fear and to do unlawful activities. And here the primary intention is to kill, is murder simpliciter.
Well, a bomb, if you install a bomb, it's not for fear. Bomb is to even kill people.
Thereafter, the cross-examination also. There also, the claimant witness 1, she has admitted that the case relates to murder and has no relation with motor accident.
Where is it?
The cross-examination of CW1, Kalpana Das. Although the pleaded case is different, but cross-examination, she has admitted something else.
What is the exact statement?
The case relates to murder and has no relation with motor accident. Now, exactly in this line, the apex court has held in this Dilip Agarwal 2026
paragraph 13, we are of the view that even on this lighter standard, that casual nexus, that has to be a lighter standard. There is no casual link that has been established. A perusal of the judgments of the court below, in a sense, assume that the injuries suffered by the deceased took place while Dilip and Anand were in the car. How such a conclusion came about is best known to them. The evidence on record does not point to any forensic proof having been recovered from the car, for example, blood, skin, cells, hair, etc. Exactly in this case also, there is no such proof that something like some blood, skin, or some cells that has been recovered from the vehicle. Neither it is anybody's case that Dilip's car is involved in any collision. Here also there is no collision. All that has been said is that the injuries sustained by Anand were by hard and blunt objects, as per the PM report. Now, true it is that the claimants need not establish the particular manner in which injuries have been sustained by the injured or the deceased, but that does not simply mean that simply because there was a car somehow involved in a chain of circumstance that led to his death, the provisions of MVA would apply. Some link whatsoever between the car and the death has to be established. So the court says that there has to be at least some evidence linking the car with the death. As because the object is beneficial, and it is to provide quick compensation to the victims who have died in a arising out of a motor vehicle accident, and not this kind of mysterious death. So considering that in mind, then paragraph 14, there is an alleged accidental murder and there is a motor vehicle, but the relationship between the two specifically involving a motor vehicle has not been established. There cannot be consequently any liability under the MVA judgments. Accordingly, it was set aside. This link, casual link, that is missing in the present case. And in the charge sheet also, it has been held by the police that the both the handyman and the driver were found dead, as information was received from reliable source from Udharban area that both the noted driver and handyman were murdered by some unknown culprit. So the term which has been used is murdered. That is my only submission.
Yes, Mr. Talukdar.
To understand the case better, you have to go through the entire chapter. Read the judgment.
Yes.
This claims case has been brought by the parents and sister for award of compensation so and so.
You come to the discussion on point number 1. That is what we are. First point. Point for determining whether
point.
killing of the deceased was an accidental murder. This is the point which is the subject matter, isn't it, of the appeal?
The
page 7, internal page 2 of the judgment.
Verse 7.
Internal page 2 of the judgment,
Lordship.
paragraph 7,
7.
points for determination.
Lordship.
Whether first point, whether killing of the deceased an accidental murder.
Whether the insurance company is liable to pay commission. What
Point number 1.
insurance. And for if the claimants are entitled.
Point number 1. Please
Point
read.
number 1. Supreme Court in Rita Devi and another person New India Insurance Company Limited and the civil and so on so pertaining to killing of driver of auto rickshaw by miscreants in order to steal the auto rickshaw. Observe as follows. The question therefore is can a murder be an accident in any given case? There is no doubt that murder, as it is understood in the common parlance, is a felonious act where death is caused with intent, and perpetrators of that act normally have a motive against the victim for such killing. But there are also instances where murder can be by accident on a given set of facts. The difference between a murder which is not an accident and a murder which is an accident depends upon the proximity of the cause of such murder. In your opinion, if the dominant intention of the act of felony is to kill any particular person, then such killing is not an accidental murder, but is a murder simpliciter. While if the cause of murder or act of murder was originally not intended and the same was caused in furtherance of any other felonious act, then such murder is an accidental murder. In the instant case, the claimant deposed while deceased was in employment and proceeding to seizure from brotherhood as the spare driver come handyman of the vehicle bearing the system. So some miscreants boarded the vehicle pretending to be passenger, but in the way toward seizure, killed both the driver and deceased, and thereafter threw the dead body to jungle and took away the vehicle. To support the said fact, exhibited police report by Exhibit 1, FIR by Exhibit 2, and FR by Exhibit 3. In the FR, the investigating officer reported that the body recovered and sent for postmortem examination, but no clue was found against the miscreant, and also vehicle was not recovered. The Exhibit 4 is PM report of the dead body of the deceased. The said PM report speaks that death was due to shock and hemorrhage resulting from cut injury present over the neck, and injury was antemortem and caused by shock, cutting weapon as well as homicidal in nature. The said documents aforesaid are accepted as reliable source, reliable because there is no challenge regarding the genuineness of the documents and facts. Moreover, the contesting OP did not bring any evidence of previous enmity of the deceased with any of the known miscreants. That is why, in my considered view, the killing of deceased and driver of the vehicle was not the dominant intention of the miscreants, but to steal the vehicle, as they committed theft of the vehicle with dominant intention of stealing the vehicle, committed other felony to kill the driver and handyman of the vehicle, to remain clueless criminal activities. That is why, applying the principle laid down by the Supreme Court in Rita Davis also, I am of the opinion the killing of the deceased is an accidental murder covered under the provisions of MB Act for order commission for legal injuries of the deceased. So here it is very clear. There is no previous enmity shown. And it is categorically stated that the miscreants boarded the vehicle And in order to steal the vehicle, they kill the driver and handyman of the vehicle. In this regard, proceed. The claimants had exhibited accident FIR. In the FIR, lordship kindly see exhibit 2-1
In the records,
record.
exhibit two.
Exhibit 2, 11 page, exhibit 2-1.
Yes.
Address to officer in charge, below lordship, for the question. It is the FIR was lost by the owner of the vehicle. Unfortunately, my above number vehicle carried the passenger towards Silchar. So far from Motherboard, but I have not been informed accordingly. Whenever I have been informed that the vehicle has not been reached within 14 hours this day, I have been bound to inform the local police station regarding the matter. Now, today at about 2 p.m., I have been informed that the driver of the vehicle named Viruna and the handyman named Chandan Das have been found dead. Informed by a reliable source of Uttarban and Lakhipur PS, the PS area by unknown person. Then what next is final report proceed. Police investigate the case, but found no clue about the misclaims proceed. Exhibit 3-1 proceed. Final report at exhibit 3 and 11 pages exhibit 3-1. Last paragraph proceed from last paragraph. The brief history of the case is that on 5/5/2007 at 2:10 p.m. The complainant Sri Sopon Chandra De, son of Sanjo, lodged an FIR. Sopon Chandra is the owner of the vehicle. At the police station to the office that on 4/5/2007, his vehicle Mahindra Savari white number also carried a passenger towards Silchar, so far from Badapur, but he has not been reached within 14 hours this day. So when he went to the police station Badapur, and later 2 p.m. he was informed that the driver of the vehicle Viruna and the handyman Chandra Das have been found dead, as information received from the reliable source from Uttarban and Lakhipur PS area that both the above noted driver and handyman were murdered by some unknown culprits. Hence, during investigation, I had visited the place PO, examining some available witnesses and recovered the stolen vehicle Mahindra Savari from Lakhipur PS area by Lakhipur. Accordingly, the vehicle was brought to the police station, observing formalities and seized the relevant documents, and vehicle was examined by the MBI and let the seized vehicle Mahindra Sabari number so timber to the complainant. She depends upon by obtaining order from the Honorable Court for you guys. In course of investigation, I have also arrested some suspect noted in columns court and forwarded them in the Honorable Court Karimganj on interrogation of the suspected forwarded accused noted in number 4 could not find out any real clue of the real culprits, but they were strongly suspected that they may be involved in this crime. Then I made several attempts to find out the real clue of the culprits, but in vain. I have made inquiry in the locality of the expert murder driver so and so. So I examined and recorded the statements of Sri, father of the said driver so and so, and found clue of these suspects from the side, from his side. Also could not find out any clue of the culprits. Passengers, as the said driver so and so informed to the vehicle owner, the complainant of the case over telephone that the passengers who had hired this vehicle were known to him as they were of his locality. I have also examined the father of the handyman Chandradas, who also in murder, but found no clue also from his side. As such, I also found insufficient evidence against the above noted arrested culprits noted for, as I discussed to the Honorable SI Wadapur and OC PS about the merits and investigation of the case, and the Honorable CI PDP also supervised the case and submit final PR, which also approved that the case is to under section 379, 302, 201. But evidence insufficient against the arrested suspects. So I submit final report of the case. The case is under section is true under section 377, 201. I wish, but immediate insufficient against the arrested suspects. But in prosecution, so I pray for the forward accused noted the person. So it is very clear that the vehicle was snatched away by the culprits. In order to snatching away the vehicle, the culprits murdered both the driver and the handyman of the vehicle. And here in this case, the intention is very important. Dominant intention. Dominant intention is to take away or steal the vehicle, not to murder or kill the driver and the handyman. So, being beneficial piece of legislation, in case maybe decided on the task of people
On the question of
preponderance of probability.
preponderance probability, that is the standard also.
And here no serious. Here intent, dominant intention is very important.
One thing, Your Lordship, I'd like to reflect from the judgment at page 8, where the court has said that this at para 11, I'll read from there. The said documents aforesaid are accepted as reliable because there is no challenge. Moreover, the contesting OP did not bring any evidence of previous enmity Regarding this, if your lordship again peruses exhibit 3.3,
Hmm.
there 1, 2, 3, 4, fifth line. There it has been stated that passengers, as the said driver, Pradhan Nath was a driver, and the passengers Pradhan Nath informed to his vehicle owner, that is this informant, that is the complainant of the case, over telephone, that the passengers who hired, that means the passengers hired this vehicle and were known to him as they were of his locality. That means the miscreants was belonging to his locality. That means these miscreants were known to this person, this driver, Pradhan Nath. So on that ground, I think they had given him a lift, and thereafter this driver and the co-driver was killed. So this dominant intention also gets established. And moreover, the complainant, when he
But
filed
but it is a fact that the vehicle was robbed, it was taken away, it was never,
vehicle was obviously
it
taken
was
away.
never recovered.
It was never recovered, but the intention could have been some valuables also from the driver, co-driver, or the vehicle also.
No, that is a speculation.
Yes.
The main purpose of causing the death is to snatch away the vehicle. That appears to be a matter of fact from the narration.
That could not be established on the basis of preponderance of probability,
Why?
because the claimant also could not show that there was any dominant intention on.
No, what can the claimant show? Claimant is a bereaved family member. She was not there when the accident had occurred.
Yes.
It all appeared during the investigation that the vehicle was found missing and they were found dead.
Yes. But
The very aspect that the vehicle was found missing, if the vehicle was left and they were killed and the vehicle left in the vehicle, then the matter could have been different. That the intention was only to kill them.
Yes.
But what Mr. Taludar is saying is that the intention the objective was to have the vehicle, and to achieve that objective,
yes,
somebody had to be killed.
killed.
So whether this will come within the ambit of accidental death.
Murder.
Till this part we are clear, but what is the difficulty is that the observation of the Honorable Supreme Court in Rita Devi. In Rita Devi, the accidental murder has been almost settled. It might come within the.
But however, in view of this exhibit 3.3, this finding.
No, we read Rita Devi earlier.
Yes.
On today's reading, this aspect has been very, very clearly elaborated.
But the previous this familiarity with the miscreants, this also gets established in view of the charge sheet. And secondly, your lordship, the FIR, which was lodged by the owner.
See, that ended in a FIR. There was not even a charge sheet.
Yes.
Had some accused been tried and they say, oh, these are the accused.
Yes.
These are familiar. There was no occasion even to go to the witness box and say that these accused are familiar or they are known to us or had an enmity. They were not there. In fact, legally, they are not even on the surface as accused.
Because sufficient evidence.
No, FIR had, it culminated in a final report. See, your argument regarding deaths occurring from the use of a motor vehicle, that though literally you may have a case after the Rita Devi judgment, apart from suppose a death by shooting while a vehicle was flying or a bomb blast. Now this, even a murder simpliciter appears to, when the vehicle itself is taken away, it appears to be an accidental murder. The expression accidental murder has been introduced.
This
Let
dominion.
us again read it, Devi. Paragraph 10.
Of Rita Devi.
Yeah, in our opinion, if the dominant intention of the act of felony is to kill any particular person, then such killing is not accidental murder, but is a murder simpliciter. While if the cause of murder or act of murder was originally not intended, and the same was caused in furtherance of any other felonious act. Now, the felonious act here was to rob, was to take away the vehicle,
Vehicle.
and to achieve that,
This person's.
this person's lives have been taken away. Okay. We might have to agree with the opinion. Okay. Yes, madam, you are for whom? You have anything to say now? Talukdar. And what is your name? On behalf of R? For R5. Okay, likha hai, they did you.
Obliged.
Now we are giving the judgment here. Uh, the instant appeal has been referred under section 173 of the Motor Vehicles Act. Hey, case amended क्यों है MECT? Bench favor. So what is it? Against the judgment and order dated 10/4/2013, passed by the learned MECT Kachar in MSc case number 804 of 2007, full stop, by the impugned judgment, comma, an award of rupees
36,000.
3,36,000 along with interest has been awarded. Full stop. The appeal has been preferred by the insurance company. Full stop. Para. I have heard Sri S. Datta, learned senior counsel, assisted by Sri Subham Datta, Siddhant Datta. I have also heard Sri M. Talukdar, learned counsel for the opposite party claimant, and Miss.
3 and 4.
Huh?
That's one or two already expired.
Opposite parties claimants, and Miss D. Pathak, learned counsel for the respondent number 5. Full stop. Para. Sri Datta, the learned senior counsel has submitted that in the instant case, comma, it would be revealed that the claimant who had that the deceased who had claimed himself, who was claimed to be the handyman, was murdered, and therefore such deaths cannot be connected with the use of a motor vehicle. Full stop. He has drawn the attention of this court to section 165 of the Motor Vehicles Act, which defines claims tribunal. Full stop. He has submitted that jurisdiction is vested upon such claims tribunal to adjudicate claims for compensation in respect of accidents involving the death of or bodily injury to persons arising out of the use of motor vehicles. Full stop. He has submitted that the present death was not connected to the use of a motor vehicle, though such death was caused inside a motor vehicle. Full stop. He has specifically submitted that the death would come within the expression murder simpliciter and not accidental murder, accidental death, accidental murder. Full stop. Para. The learned senior counsel has submitted that though the learned tribunal had taken into consideration the case of Rita Devi versus and others versus New India Assurance Company Limited, reported in 2005 SCC 113, the facts of the present case are distinguishable. Full stop. He has submitted that in the case this is not submit. Full stop. He has also placed reliance upon a case decided by a division bench of this court, reported in 2005 3 GLT 465, wherein an appeal by the insurance company against grant of award was allowed and held that since the death was not a result of an accident but an act of homicide, a claim under the MACT, under the MBA Act would not be maintainable. Full stop. Reliance has also been placed on a recent judgment dated 2000, the judgment reported in 2026 SCC online SC 1374 bracket Dilip Agarwal versus Rashri Agarwal and others. Full stop. He has submitted that in the said case, it has been laid down that a nexus has to be established between the accidental death and the use of a motor vehicle, which is not present in the instant case. Full stop. Para. Per contra, Sri Talukdar, the learned counsel for the claimants, has submitted that the judgment passed by the learned tribunal would squarely be covered by the ratio laid down by the Honorable Supreme Court in the case of Rita Devi Supra. Full stop. He has submitted that the dominant cause of the murder was to steal the vehicle, which would make the death an accidental one connected with use of the motor vehicle. He has also drawn the attention of this court to the observations made by the Honorable Supreme Court in the case of Rita Devi Supra, wherein the aspect of accidental murder and murder simpliciter has been explained. Full stop. It has been held that when it appears from the facts that it is an accidental murder, a claim would be maintainable. Full stop. Ms. Pathak, the learned counsel for the respondent number 5, has submitted that she would not have should not have a significant role in the adjudication of the present appeal. Full stop para. The facts of the case which has been elaborately narrated in the impugned award is not in dispute, full stop. Though there is some dispute with regard to the employment of the deceased as to whether he was a spare driver, cum handyman or handyman, comma, it is not in dispute that he was found dead along with the driver in the vehicle and at a place, and the vehicle was found missing. Full stop. The records also reveal that though a police case was registered, comma, the same had culminated in a final report. Full stop. From the facts and circumstances, comma, it clearly appears that the intention to cause death was to achieve the objective to steal the vehicle. Full stop. In this connection, comma, the observation made by the Honorable Supreme Court in the case of Rita Devi are to be taken into consideration, which read as follows, paragraph 10. Full stop. Para. It clearly appears that the dominant intention in the instant case was not to kill the husband or what? Not to kill the son of the
Son.
not to kill the deceased, but to steal the vehicle, and for achieving the same objective, the killing had to be done, full stop. In the opinion of this court, comma, the present deaths will come within the ambit of accidental murder as explained by the Honorable Supreme Court in the aforesaid case of Rita Devi Supra, full stop. This court has also noted that the amount which has been awarded is not on the higher side, but appears to be reasonable, full stop. Under the facts and circumstances, comma, this court is of the opinion that the impugned judgment dated 10/4/2013 would not require any interference, and accordingly the appeal stands dismissed, full stop. Let the records be sent back immediately. You have paid half, 50%.
50%.
The balance amount and at this stage, comma, Sri Dr. the learned counsel for the petitioner, for the appellant, has submitted that 50% of the award was already paid, full stop. The balance 50% may be paid. Balance amount as per the award be paid expeditiously in any case, expeditiously, and in any case within a period of 1 month from today. We have said interest as per the award. We have not said balance as per the award.
Your Lordship, the statutory deposit also, that may be refunded.
The statutory deposit made by the insurance company be refunded by the registry within a period of 45 days from today. Last part to কি কইছিল যে ইন্স্যুরেন্স কি ইন্টারেস্টের কথাটা the balance amount as per the award, ঠিক আছে। You can. Yes. Mr. Goswami. Item number 17. Yes, other side.
Other side is not there.
Miss Sankakoti, Miss MSS Sankakoti, P. Burman. P. Burman would be Madam Puri Burman, perhaps. P. Burman.
Yes, yes. Originally it was one by one, equally taken.
That case.
That case, Lordship.
How much is the award?
But the award was for 9,87,500. What has happened, Lordship, in this case?
What are your grounds of challenge?
Found, Lordship, this appeal was filed, this claim petition was filed under section 163A. That was with a structured
Structured
compensation
formula.
unit.
Hmm.
During the pendency of this appeal, Lordship, the act was amended.
Hmm.
It was initially the section 163A was amended by notification separately. Then finally, when the act was amended, it now has become 164. Now, question is whether this question has been raised in various issues. It has also been decided by Supreme Court whether in the pending cases this amendment would apply retrospectively or it will apply prospectively. On this has been decided by our Honorable Gauhati High Court. The Gauhati High Court has been followed by Rajasthan High Court and other High Court. Even Calcutta High Court also has held a judgment that has been approved by Supreme Court. That this will apply
Prospectively.
This will apply retrospectively. This being a procedural liability of the company remains, but how much should be the amount? That was considered to be procedural. And in case of procedural amendments, this would apply, it has been held by, this would apply retrospectively.
Where has it been held? Which case? Which case?
Not sure, yes. Initially, it was, I'm giving up Gauhati High Court, then also of other.
But unless the statute says that it will have retrospective
Yes,
effect, how do
but,
you?
I
Statute
can
is always prospective.
No, I'll come to that also.
Suppose
This-
you make smoking an offense. Can you penalize a person who has smoked 10 years back?
Let's say, I'll some humble submission to make it.
Judgments
this
are
notification
retrospective.
was
Judgments are retrospective unless it's so.
Yes.
Statutes are prospective unless something else has been explained.
Lordship, this notification was Lordship issued. This has come in by way of substitution. And substitution, Lordship, makes it, the mechanism of substitution, when it is it makes it the original provision ceases to exist as if this was the provision from the beginning. There are judgments of Supreme Court. I have gone through this provision entirely. Supreme Court has held that when an amendment is brought in by way of substitution, then it becomes retrospectively applicable. As if
No, what is the case?
Lordship, yes. What's this amendment, Lordship?
No, for case law.
Case law. I had a write-up today, Lordship. I am giving the case law along with my write-up I had made.
But other side,
That is not there.
can you bring them? P. Burman.
I don't know. I thought it would be here.
You try to locate them. We'll have them in their presence. Puri Burman.
Puri Burman.
Names are reflected in the cause list.
You remember tomorrow also, Lordship.
Tomorrow
try
we can,
to find out.
tomorrow we can try. Tomorrow we can try. Though 3R Goswami, learned counsel for the appellant, is present, comma, the learned counsel for the R6. 6 may not be the claimant. Let us see. No, 1 to 5 is entered appearance. Who was 1 to 5?
For 1 to 5, Mr. A.K. Sigdar's name was there earlier. Ours.
Bluetooth phone appearance. Blue file to show. Blue file to show kalu kalda mase. Blue nine again. Hale ibla kata 30 second to take. 6R6. Therefore, R6. Claimants are 2, 3, and 4. I think claimants, somebody else is there. R6 may not be,
Yes, Lordship.
presence of R6 may not be
May not be necessary. 1 to 5 is A. Sigdar's name was there initially.
Where, but, asani ki naam?
A.K. Sigdar.
Na kiwitan ha, wakalat naman. Because there is an order, Mr. Goswami,
Yes, Lordship.
of 3/10/2018. Today, the learned counsel for the respondents 1 to 5 has entered appearance.
Yes, Lordship.
But names have not been reflected. Who were the counsel?
I have made a note. It was Lordship A.K. Sigdar. In my file, I had made that note.
Can you inform him?
I'll find out if he's still there.
Wakalat naman ay dili kini kaya. So, ito chosun. Wakalat naman sa ni.
Lordship,
I'm sorry.
when Lordship tomorrow day after?
Just a minute. Let's see the wakalat naman. Mukhi kini jasan. Tolo record to na lage. Ikini lage. Caveat na lage. Ye to na lage. This is not okay. It's not. Tolo from last one. Last is to key con last one. I got on again. Last. I got on again. MSC. And last one. MSC did nahi got. All Wakalatama is also not there. I do not know how. And that is why the office has not reflected the names. You verify from him.
I'll try to
Okay,
talk to Mr.
okay.
A.K.
Ki bolo? For the respondents are not present, full stop. Para, in the interest of justice, matter is adjourned to be listed again tomorrow. Or listed again day after tomorrow.
Yeah.
MSCT matters only on Tuesdays and Thursdays.
Right.
It's been distributed across all the benches.
Yes.
That is what the information is. Okay. Thursday. Okay, next.
May it please. Sir, in this case, my lord, accident of 2013, my lord. In the year 2016, my lord, my claim petition had been dismissed, my lord, saying that this is not negligent, my lord, solely relying on the JD entry, my lord, without citing any evidence, my lord. So,
Your claim petition was dismissed
Dismissed,
on
my
the
lord.
ground?
on the ground that, my lord, the deceased is, my lord, not, the deceased was negligent in driving, my lord. Only relying on the GD entry, my lord.
No evidence was used.
Evidence were adduced, but not discussed in the judgment, my lord. It's a case of to remand, my lord, in my humble submission. Otherwise, my lord, the long pending case, accident occurred in 2013, my lord. So it goes back also, it will take time again, my lord.
Where is the judgment?
Judgment is at page, my lord. Page 15, sorry. Page 14, my lord. Relevant paragraphs, sir, my lord. Decision and reasons at page 16, my lord. 7, 8, 9, 9, my lord. In 3 paragraphs, my lord. Mainly 9, my lord. 8, 9, my lord. Evidence of eyewitness was also there, my lord. That has not been also been considered and cited in the judgment.
Who's DW1?
Wife of the
No, DW1, Rajesh,
DW.
Maybe he was an
your,
investigator.
your employee.
Investigator or.
Oh. Dismissal perhaps may not be proper. Contributory negligence may come in, may come in. And degree of proof is also different. You cannot go by the standard of proof in a criminal case. We remand it back, okay?
That's a lot. But otherwise, my lord, we thought
My
it
lord.
can be.
Sorted out by
here
this.
itself,
Yes, my lord.
Resolved here itself.
Yes, how much are you claiming? Somebody has died.
Yes, my lord. But that calculation has to be made, my lord, by both.
You can sort it out.
My lord.
Let us try, my lord, if it can be done here itself.
Yes,
Because
Thursday.
remand will again take
You're
2
right.
years.
Thursday.
Thursday will be too early, my lord, sometime, because I
Okay.
don't have anything.
Okay.
I have to borrow documents
Okay.
from him.
Heard Sri P. Sundi, learned counsel for the appellant. Also heard Sri R.K. Bhatra, learned counsel for the opposite party insurance company. Full stop. The appeal has been preferred by the claimant whose claim has been dismissed by the impugned judgment. Full stop. The learned counsel has submitted that the grounds for dismissal is based on a GD entry regarding the accident, wherein it has been stated that the accident was caused by the rash and negligent driving of the deceased. Full stop. The learned counsel, Mr. Sundi, has submitted, Sri Sundi has submitted that such a course of action perhaps would not be the correct approach in deciding a claim made under the Motor Vehicles Act, which is a beneficial piece of legislation. Full stop. Para. This court is of the prima facie opinion that the contention advanced by Sri Sundi, the learned counsel, may have some force. Full stop. At this stage, this court has also looked into the aspect that the accident is of the year 2013 and the impugned judgment is of the year 2016 and more than a decade has passed. Full stop. This court is of the view that an order of remand may further delay the matter. Full stop. At this stage, Sri Bhatra, the learned counsel for the insurance company, pressed for some time to obtain instructions as to whether there can be any amicable settlement of the matter. Full stop. Para. In view of such submission, the matter is adjourned to be listed on, we'll have it on 8th of September.
Can it be on 15th?
15th it will not be, yes, 15th of September.
Okay.
Much okay.
Respondent.
Hmm.
It was dismissed by the learned tribunal as a false case matter.
Where is the judgment? Where is the judgment, Mr. Biswas?
Page 37 times, Act 7. May I read, ma'am?
No, just that part.
Yes, page 37. Oh. In course of trial, claimant most Asma Khatun advanced her evidence report scored as PDU one Akbarali, who is not an eyewitness of the incident, testified as PDU two, and his evidence exhibited from 54 the FIR charge sheet, list, post-mortem report, and document regarding the medical treatment of Sakina Dewa. In our case, in hand, the learned advocate for the OB number 1 and 4 asked no such question to doubt their story claimants. However, some undisputed facts have come to play. They are that the alleged incident occurred on 16/10/13. FIR was lodged in 22/8/14, and the alleged injured victim died on 4/9/14. In the FIR Exhibit 2, the name of the rider of the offending vehicle
Yes,
is
we have seen.
Afijul.
We have seen. We'll give one more chance, then I'll.
Yes, I have.
Okay. None appears for the appellants on call, whereas Sri S.C. Biswas, learned counsel for the
3 and 4.
respondent numbers 3 and 4 is present. F.A. Hassan for whom? Yeah, F.A. Hassan is with,
Here, my answer.
Hassan is with you.
And it's for 2, and for it's not 2 much.
2,
Yes.
2 and 3, or what?
Only 2 much.
Only 2. Even on the last occasion, that is 25/4/2024, there was no representation on behalf of the appellants. Para, be that as it may, and in the interest of justice, another opportunity is granted to the learned counsel for the appellant to make representations. Full stop. Para, list on Thursday. Full stop. It is however made clear that in case of further non-appearance, this court would pass final orders, appropriate orders, don't say final, appropriate orders. Thursday, day after tomorrow. Yes, Mr. Mondal.
Your Lordship, my grievance is that I have exhibited ITR returns as exhibit 1, 2, and 3.
Death case.
Death case. And if your Lordship come
Then you're coming for enhancement.
Yes, enhancement. Your Lordship.
How much is granted?
Awarded amount is 3,48,000.
What did you do?
I'm a businessman.
This is the businessman.
Business.
What kind of business?
It's a vehicular business on rent. I give on rent.
The accident was in which year?
Accident
13.
2007.
7.
2007.
What type of business that is not?
What are your grounds of enhancement?
My grounds of particular grounds of enhancement is that my income tax return was not at all considered. Not even a single line has been written in the judgment about
You
that.
had exhibited those, proved those.
Exhibited, yes.
Proved those.
I have not called any witness.
No, not necessarily. You had proved.
Yes. Along with that ITR returns, I have given that balance sheet from what source. Everything was exhibited. That was not considered. And even in the judgment, if your lordship come to pay.
As per your IT returns, how much would be your monthly income?
Your lordship.
How much has been held? How much has been held by the learned tribunal?
Tribunal has held, it has made a guesswork of 3,000 only.
Notional.
Notional.
And how much is your expectation or?
My income, if your lordship, my last assessment year income is 1,73,174 annual income.
So monthly?
Monthly, your lordship. In my evidence also, I have stated it
7,000.
14.
Huh?
14,000 odd. In my evidence, I have said that.
You are a married person or bachelor?
Yes.
Married.
Yes. The claimants were the wife and the children.
How many children?
2 children. At that relevant point of time, both were minor.
Yes, madam. Can anything be done?
Regarding the income lordships, in the evidence is stated that C is.
These matters are perfect matters for Lok Adalat. Why has it come for adjudication? We would have forced madam to accept something. Here we cannot. Huh?
No, your lordship.
Quit him that let the matter be settled because it's on quantum only. Even then, lordship, so far.
Why did you settle these matters in Lok Adalat?
Your lordship, in Lok Adalat, this matter cannot be settled, I think.
Madam is agreeing.
It's a quantum lordship.
It's only the quantum. The Lok Adalat can force the insurance company to accept which is reasonable and fair. It's not a windfall.
Your lordship, nowadays, what happened? In Lok Adalat, the list are sent by the insurance company. Insurance company send the list. If they agree, then only it will be settled.
She has said that she has her consent to have this matter settled.
If my learned friend.
Yes, I will try, lordship, because it's a.
Not try. Because this.
Record is.
What do you, madam, irrespective of the outside, not in terms of your brief,
Otherwise, lordship.
not as per your brief you're holding, what do you say out of the records?
Lordship.
Is there any possibility?
Yes, lordship, there is a possibility because lordship, in absence of evidence, it was taken to. They have filed the document, lordship, it was not proved. Even then, if I say that it's not legally proved, and if I go through the records, then I'll say that no one has come to prove, and so far as Honorable Supreme Court's decision as well as our High Court, that mere marking of a document as exhibit does not amount to.
This is in a civil proceeding. We are not in a civil proceeding. Civil proceedings are adversarial. These are not adversarial. Yes, you have an opportunity to contest a claim, but will not go by those rulings in a civil case. Mere marking will not dispense with the requirement of proof. That is the law, but that is in a civil proceeding.
And
here it's a tribunal. Before a tribunal, the primary intention to see whether some compensation is entitled to, and if so, how much will be a fair amount.
Yes, it's a beneficial.
How much will be a fair amount? That is no windfall, but it should not be less. But this you cannot, and there are other earlier laws that the doctor has to come, or police has to come. Everything has been made easy.
Yes.
No doctors required, no police required. Why? Because a person who has lost somebody is already under distress. So to make things easier.
And if you go through the income tax return also, lordship, it does not come 9,000, 8,000.
How much?
I have calculated roughly, it comes to some which is five, in first, third one is given after the death. Third
The
one.
assessment here.
And first and second is, it comes to monthly income as 8,000. And in the second one, it comes to 4,329. And rent amount he's getting. So some in between that we can try now, if my learned friend agree.
How much is granted? 3 lakh,
380.
380.
Abandonment lordship.
Amount has been
Three
discharged.
48, your lordship,
You have paid
348.
the amount.
It's a case of 2007 lawsuit. And in the 2007, there is a lordship, national income is to take as 3,000. There's a decision of that time lordship.
Your
You
lo-
tell us, Mr. Mondal, what do you, how
Your
much?
lordship, in the learned tribunal, in para number 12, has categorically mentioned that the claimant in her evidence as well as has said that his husband has earning 15,000 per month.
After that,
Huh?
just started, after that,
Huh? You tell us something how it can be resolved.
Though, your lordship, the finding of the court is though the claimant number 1, claimant CW1 deposed her husband earned rupees per month, no documentary evidence has been furnished to show that her
No,
deceased.
that is what we are asking you.
since he's doing, he
No,
cannot.
no documents, your lordship,
He's
not
not
about
saying-
business.
In cross exemption, he stated, I do not know what type of business he used to do. In the cross, lordship will find. In the cross, it is here. I do not know what type of business.
See, there would be a difference if a document is in the nature of, suppose, a salary certificate given by a private employer and an IT return. IT returns has got
It
a
is-
statutory color.
Yes.
So you need to put this on a different footing, higher footing. So even if the lady, the wife who is in distress is not able to specifically state what was the business of her husband, that itself may not be a ground to disbelieve.
Lordship.
And it's not a question of disbelieving. He has not discussed. He could have discussed and disbelieved. That's a
Yes,
different
yes,
matter.
yes.
That this is not enough. But this has not been proved by the appropriate authority. But there is no discussion. So if there is a discussion, there might be a change in the amount.
Yes, lordship.
Your
Can you
lordship,
get instructions, madam? We can,
Yes, lordship.
your lordship,
Mr. Mondal, let her.
if my learned friend agrees,
Yes.
How
No,
can I agree?
no,
My
to-
client will agree.
No, today she will not be in a position to give some
no,
commitment.
even
Let her have the instructions.
if both of us come to an agreement
Yes,
that
yes.
this should be taken as an income, then
No,
the
no.
matter can be
See,
settled.
from your side, it's not difficult.
Yes.
Yours is a private
Yes,
client.
yes, yes.
Hers is an institutional client.
Yeah.
Unless it comes in the form of an instruction, it will be difficult for her tomorrow.
Yes, your lordship. Yes.
Unless it's an order of the court.
Yes.
And we don't want to enter into the merits. If it comes from you, it's good. Heard 3D Mondal, learned counsel for the appellant who has preferred this appeal, praying for enhancement of the award contained in the judgment dated so-and-so, passed by the learned so-and-so in MSCC case number so-and-so. Para. Amongst others, the learned counsel for the appellant has contended that the claimant, who is the wife of the deceased, had exhibited and proved the IT returns
Yes.
to prove the income, full stop. However, there is no mention in the impugned judgment about those leading to, which culminated in the award containing a lesser amount.
Yes.
Full stop. Para. On a perusal of the judgment, it indeed appears that there is no mention or discussion about the IT returns. Full stop. Para. This court is of the opinion that an attempt can be made for resolving the matter through an amicable settlement. Full stop. This court accordingly directs Ms. M. Chaudhary, the learned counsel for the insurance company, to take appropriate instructions so that an amicable settlement can be arrived at. Full stop. Para. Matter accordingly stands adjourned to be listed on.
Your lordship, it can be listed before the Lok Adalat also.
Is the Lok Adalat
Yes,
coming?
yes, yes.
In the next Lok Adalat, which is scheduled.
Maybe listed.
Highly obliged.
Please follow it up with the registry, with this order, so that it can be placed before the Lok Adalat. No amicable settlement. Mediation also tried.
Matter was hard also.
Heard.
Something they use.
Against an award.
Yes.
How long will you take? Will it be possible today? You can try. No?
I think 2-3 ground also.
You are the workmen
Yes.
union. What is the award about?
It was regarding the termination of service.
That was interfered, that has been upheld.
They have not interfered, they uphold that order.
Termination
it
of
is an
service has been
ex parte
upheld by the labor court.
Labor,
Or it is tribunal, which one?
labor.
Labor court.
It is an ex parte order. Ex parte order, what happened during the pendency of this court before the labor court? The advocate of the workman side expired. That information was not
Communicated to the labor court.
labor court. The advocate of the workman, B.N. Sharma, was there. B.N. Sharma expired. So they are not does not inform properly. That is why they could not.
In the hearing, there was no representation.
Hello?
In the hearing before the learned labor court,
Yes.
was there any representation from your side?
No.
Were you represented before the learned
No,
labor court? Not represented.
This requisition is structured.
Hmm?
Basically, 3 grounds.
No, if it was not represented, then what do you say? We are not,
Yes,
not on the merits.
that award was passed on 15/11/2010. What happened, Lordship? The preliminary issue was raised.
Award. Thereafter,
Thereafter, the fresh notice was issued. That notice was delivered
why first notice?
because the union's representative was not.
No, you said the award was already there on 15/11/2010.
Award was passed on
15/11/10,
15/11/2020.
2010, yes.
And this requisition was filed on 2018, after 8 years.
Oh, it's a 2010 award which is
Yes.
put to challenge.
And 18. And it is not the case, Lordship, expertly, because the pursuant to the date of the Learned Council for the workmen, Lordship, fresh notice was issued. That was, they have not stated in the decision. Fresh notice was issued, that was received, Lordship, if Lordship use the court's record, Lordship, that is already.
They had received the notice.
Yes.
Even thereafter,
the
they
requisition as
the
a final
workmen-
by the union. Union is the representative, the workmen.
No, union after receipt of the notice did not take steps
Yes.
to engage a new council.
And apart from that, Lordship, one of the ground that no opportunity was given to the workmen, Lordship. However, if Lordship the peruse the award, straightway Lordship page 51.
Hmm. Yes.
Because although three workmen were terminated, Lordship, the paragraph 7 of the repetition, in respect of two others, they have not only the dispute is regarding one. Now one Tilok Tosa. Paragraph 7 of the repetition is that the petitioner begs to state that during the pendency of the case, two workmen, namely Meghnad Kumar and Baneshwar Nag, due to their actual financial problems, submitted a revision and settled their dispute with the management, and as such, the petitioner union has prepared a dispute on behalf of the workmen Sri Tilok Tosa. So regarding the Tilok Tosa, page 51, paragraph 7 of the award. MW1 states that he conducted domestic inquiry against Sri Tilok Tosa on 25 May 2006, and Exhibit 11 is the so-called notice charge sheet. And Exhibit 11(1) is the reply of Sri Tilok Tosa denying the charges leveled against him by charge sheet dated so and so. That means he has participated. Thus, it is proved that the charge sheet was properly served upon the concerned workman, and he also pleaded not guilty. MW1 further states that notice of inquiry was served by Exhibit 12 upon Sri Tilok Tosa, and he duly received it where Exhibit 12(1) is his signature. And he also participated in the inquiry. And manager examined three witnesses, namely one Notingwala, Dori Tosa, Soikat Bose, and Exhibit 13 is the inquiry proceeding against Sri Tilok Tosa, wherein Exhibit 13(12) to 13(22) are the signature of Sri Tilok Tosa, and all the three witnesses of the management were cross-examined by Tilok Tosa, and that the inquiry was done in presence of two independent observers, namely Sharma Urang, Nirmal Nag, and that Exhibit 14 is the statement of Sri Tilok Tosa. Thus, it is seen that the concerned workman Tilok Tosa participated in the domestic inquiry actively, and he also cross-examined the management said witness. Thus, it is found that the domestic inquiry held against Tilok Tosa is lawful. So, this is contrary to their averment in paragraph 6 of the repetition, wherein they have stated that no opportunity was granted without following the process of law. Regarding their next ground, paragraph 14 of the repetition. The petitioner begs to state that after the date of their counsel, they could not take steps to adduce evidence and argue their case before the court. The learned labor court, ignoring the facts of date of counsel of the workman's side, did not take steps to issue notice to the workman regarding the continuation of the proceeding. And before the workman could take steps to engage new counsel, the learned labor court proceeded the expert. If Lordship peruse the page 9 of the lower court report,
Mr. Kolita, we are on the aspect that whether in the labor court they had got an opportunity.
Yes.
Where is the finding?
it is expert interest, because even after the notice
Expert.
was served, Lordship, even after notice was served, they could no one represented. And the union, since the union is represented,
No notice was served, my lord.
page 9 Lordship.
Notice was served, notice may be, I don't, notice may go to the garden, but not served to the workman.
Because the union is represented in the eastern phase, and Tilok Tosa has filed affidavit.
There is no,
If Lordship see-
there is no receipt, there is no receipt on behalf of the workman. No notice was served. No notice was served. It's an expiry order and it is a.
But what, how do you explain your conduct in approaching this court after 8 years?
Yes, Miller, that delay is there, delay is there.
And Lordship, another aspect.
Oh, just a minute, just a minute. How do you explain 8 years? You had accepted the award.
The workmen, the poor workmen, they could not understand the matter. Well. There's the-
No, 1 year you do not understand, 2 years, 3 years, 8 years.
Yes, Miller. Delay is there. It may be remanded to the labor court.
No, remand why? First you have to satisfy. this court, what caused the delay? See, there would be this recourse available to the court. We can dismiss on the ground of delay
The fact is
in
that
coming to the court. Now, just listen to us.
in this case
Mister,
originally,
just listen to us. The options which are left to the
Yeah.
court, we can dismiss on the ground of delay.
Yeah.
Second, you might argue that since the matter has been admitted, so why do you take up the aspect of delay at the time of final hearing? If we accept that, then it is the case of ex parte judgment,
Yeah.
where admittedly you were not heard. Mr. Kolitam would definitely take up the issue that notice was also issued when your initial advocate had passed away and you neglected to defend yourself. So that may be a ground against you. But lastly, if we are agreeable with you to have the matter adjudicated on merits by giving you an opportunity, that can be done either by this court or by remanding to the learned labor court.
yes,
Remanding after so many years of a decision of 2010 perhaps will not be proper. We can decide on our own. You can make your arguments on merits. We decide it. Somebody has to take the burden. We take the burden.
then the fact is that initially in this case, 11 workers were succeeded.
No, we will be confining ourselves to TOSA. The others have abandoned. They have not abandoned, they have settled the matter.
No, Lordship, that is also wrong statement. Because this revision is structured by making some false statement. That's why the petitioner has not approached this round with clean. Because if Lordship peruse the paragraph 7 as well as the paragraph 19, wherein they have stated some ground, Lordship. We have in pursuance to that, this one of the court order, we have also obtained the instruction regarding no already that instruction was placed, Lordship. I think
Yes, what is there?
no records at the state for other APS workers who have approved the management. That is also wrong statement, Lordship. Apart from that, they have again taken a ground, Lordship, is paragraph 90. That one, the manager who was, he has issued the charge sheet, as well as he has also the disciplinary report. He has also issued dismissal order. That was one of the ground. That is also wrong. And regarding the notice also, the records reveal that they have received.
Then we can hear it on merits. You can urge your grounds or on the grounds of objection, then Mr. Das, we can hear it, yes.
Yes.
Please have your seat, let Mr. Das. Mr. Sharma, which matter? May not be possible today. Unnecessarily, why should we keep waiting? Who is on the other side? Excise. We'll have some other date fixed. Matter of which year? 24. We'll give a date. Paucity of time, may not permit the matter to be taken up to the list on so. Our naam kata lekha diba, Heard Sri R.P. Sharma, Senior Counsel, and S. Sharma, Learned Counsel representing the Excise Department.
Yes, my lord, this case relates to an incident occurred on 24/9/2005.
24/9?
24/9/2005.
2005. What incident?
Regarding bonus, my lord.
Regarding bonus?
Regarding bonus, an incident occurred. In that incident, there was a police firing, and one worker also expired.
There was firing.
There is a police firing, and one worker expired. And that matter was regarding payment of bonus of 20%.
Yours is a, what industry? Tea garden or what?
Tea garden.
Tea garden.
Tea garden.
Where is your tea garden located?
Manawari Tea Estate.
In Sonitpur.
Sonitpur.
Hmm. Thereafter,
Thereafter, my lord, the management initiated action against 11 workers. My lord. They suspended 11 workers.
hmm.
Subsequently, the management withdraw suspension letter against 8 out of that 11. Against 8, they withdraw the suspension order and initiated proceeding against three workmen, Nagnat Kumar, Baneshwar Nag, and Tilak Prasad.
Hmm.
The whole incident occurred there under the leadership of the Union ACMS, Assam Samadhi Group. But this ACMS, afterward, out of this 11, the suspended worker, 8 were ACMS member, but other 3 were other newly formed organization, Sangami Samadhi Sangha. So the management, in fact, the victimized the 3 workmen who are not member of ACMS. And these 3 workmen were all member of Sangami Sasamud Sangha who are not ACMS members. That is why the police, the management sues them and take action against them. Out of these 3 workmen, like 2 have subsequently submitted resignation and took their full and final settlement. Only Tilak Prasad remains. Tilak Prasad challenges the action of the management and a industrial dispute raised.
Yes.
And ultimately, a case has been referred to the labor court. In the labor court, the union engaged one advocate, B.N. Sharma, and other management also. Both the parties submitted their written statement and initial written statement. Thereafter, suddenly the advocate of the workman side, B.N. Sharma, expired, which was not communicated to the union in time. And that is why they could not attend the labor court for some dates. And when they got the information about the death of their advocate, in the meantime, the labor court passed this award, upholding the action of the management. And in that incident, below, there was there allegation against the workman that they manhandled the manager, one manager, and but there is no police case. There is no allegation of manhandle there, but there is no police case. And in the inquiry, the domestic inquiry was conducted, but the workman was not given opportunity to defend his case as per the norms of the domestic proceedings of inquiry proceeding.
But just now, cursorily, we have gone through the judgment. In the domestic inquiry, the workman appears to have been given notice and he participated.
He was appeared.
That he had participated in the domestic inquiry.
But he was not allowed to take assistance of a co-workman of his choice. A ordinary workman, how can he conduct, how can he?
Are these grounds that you are not given the opportunity of a defense assistant? Have you taken those grounds?
in that inquiry, not,
No, now that you are
Yes.
saying,
yes.
have you taken those grounds that you have not been given the opportunity
Yes,
of a defense
yes, we
assistant,
taken the ground at the labor court,
labor court,
yes,
in the WS?
in EWS.
Okay.
But subsequently, the land labor court passed the ex parte upholding the action we. In the meantime, the other two out
What
of
was the action taken? Dismissal or termination?
the termination.
Termination.
And actually, before starting the ex parte proceeding, a notice should have been served to the workman. But no notice was served. Notice could have may, I do not know, but notice could have served to the garden, but garden management has not served that notice to the workman. Workman was not aware of that. And there is no evidence also before the labor court that they have received, the workman received that notice. Or the concerned union has received that notice. There is no. And Millard, fact is that in the meantime, the workman has already retired, Millard. For the already also 5 years back, he attained the age of retirement. Millard. So at this moment, there is no question of reinstatement. Only question of payment of his full statutory dues remains. At this moment, only there is a question of payment of statutory dues to the workman. So that is why we have proposed before the year that may be settled through mediation. But in the mediation, the management did not agree for any settlement. So at this moment, our claim is yes, is only to give the statutory benefits as well as some compensation. That is our claim.
But in that case, we have to set aside the order of termination.
Yes. No, that order of termination may be set aside, may not be set aside, but your lordship can also.
Now, if it is termination order, how do you get your dues? If termination order is not set aside,
Yes.
if that stays, if that remains, how can you maintain a claim for statutory
The lump
dues?
sum amount may be paid. Millard.
Now, on what basis? Your termination has to be interfered with. Without the termination being interfered with,
The
what,
Yes, as per the order is to be set aside.
unless it is interfered with, that consideration we cannot make, whether it be entitled to anything.
As per the order may be set aside and direct the management to pay some lump sum amount as statutory benefit.
Now, we can decide it here itself.
Yes, Millard.
On merits, what do you say?
Lump sum are equivalent to the
On
statutory.
merits, you had adduced evidence. How many witnesses? They had also adduced evidence. At what stage it had become ex parte?
We have no
Well, preliminary issue was framed.
On the fairness?
Yes.
On that? Or the stage of adducing evidence before the labor court did not come?
Because preliminary issue was framed.
Okay.
And accordingly, the preliminary was so the domestic found to be right.
So, and in accordance with the said finding, reference has been answered.
As per Ludwig C.
The preliminary inquiry fairness has been decided in their favor.
Yes.
So there is no requirement to again go into the merits. Only if the management fails, as per Ludwood, they can adduce evidence on merits of the case. Now they have succeeded in proving the fairness of the domestic inquiry. Their job, they have discharged, the burden has been discharged.
No, if the matter has remanded back to the labor court, then union will get opportunity to adduce evidence on the domestic inquiry and marriage.
He is also surpassed the age of superannuation 5 years back. What remains now to be decided? So when was the termination, Mr. Kolita?
Termination order was on 9/8/10/2015 in respect of
Tushar.
Prosa.
In could have been settled by paying some amount as
Suspension order was issued on 8/10/2005. Surseat was issued on 26/10/2005.
Termination?
Termination order
not this. Dismiss on 5/12/2006.
5/2.
5?
5/12/2006. They're dismissed.
And the reference was registered when? Which year?
2008.
8.
Reference case
2008.
number 11/2008.
Yes.
Appropriate government referred the issue on 11 March 2008. Or 31 March 2008. 31 March.
An ex parte award was passed on 15/11/2010.
Hmm?
Out of 3, other 2 were paid some amount.
But it has gone for mediation, it failed. So now in that direction we cannot give. We can give provided we find fault with the decision making. The termination, that let us see your written statement, Mr. Das.
Yes.
Written statement. Written statement.
Yes,
WS.
Page 42 and 45. Page 42 is the written statement and page 45 is the additional written statement. Last now, Peru's concept regarding the defense witness B, as stated by financial friend. And 45 is the additional written statement.
Where are your, there are no pleadings. No pleadings that no defense assistant was given to, no, was not given to you. No defense assistance was given to you. 42 and 45, if what Mr. Kolita has shown is correct, 42 is the WS, 45 is the additional WS.
Yes.
And in the application also, I don't find.
The dismissal is arbitrary and against the rules of natural justice.
Leo was tried to explain in paragraph 26. There is rule the 26. Page 9. That the workman approached the management again after the award of planet level for make a prayer to review his case and allow him to continue his service. The local manager of the garden assured him to discuss the matter with the higher management and allowed him to stay in the quarter along with these other members of the family. The workman was waiting with a hope for a positive response of the management. But the local manager of the garden delayed the matter on various ways. Daily is shown by the skin of PROCEED itself.
The only difficulty is with the ex parte approach. Otherwise, we are not inclined to give any relief. Only ex parte, how, that is what is causing a problem. We can do one thing, we'll have some more hearing. Tomorrow we'll hear it. Anything, Mr. Das? I think that is all you have to submit. Or if you want to, within 10 minutes, you can complete it. Yes, complete it.
This is the case, Lordship. With the pursuant to the proceeding, Lordship, the workman was terminated, Lordship, on by 14/26/2005.
Now, 5/12/2006, you said it was terminated. 5/12.
There is some already, the petitioner, my first suggestion also, the petitioner has not approached this honorable court to clean him.
Why?
Because if the affidavit is shown, paragraph 14 is shown as a record, matter of record.
40.
14.
Yes.
Wherein it was stated that after the date of their counsel, they could not take steps to reduce evidence and argue their case before the court. The learned labor court, ignoring the facts of the date of the counsel, the workman's side did not take steps to issue notice to the workman regarding continuation of the proceeding. And before the workman could take steps to engage new counsel, the learned labor court proceeded the case ex parte and pass an ex parte order in favor of the management. On 4/11/2009, the preliminary issue was fixed for hearing. Page 6 and 7 of the labor code
Record.
Yes. 6 and 7. I have fake mark.
Date fixed for preliminary?
hearing on the fairness of the domestic inquiry. As on several
Hearing, which were the date fixed?
on 4/11/2009. As none has appeared on behalf of the workman lordship, fresh notice was issued on 28/5/2010, page 9. 28/5/2010.
28/5.
Yes. Page 9 of the LCR.
Yes.
On 3/8/2010, AD card returned after service. And thereafter on 18/8/2010 lordship, for hearing the parties, page 10, ex parte award was passed.
No, to proceed ex parte.
Yes.
And into the, okay,
So in the case
1810, 18/8.
18. Ex parte award.
Notice was served in the garden, probably,
No.
but not to the workman.
Union represented because the case was represented by the union. It's not the case the workman himself appeared. He has filed this. And the records reveal this. Regarding the petitioner's one averment that no opportunity was granted lordship, I have already drawn your lordship's attention. Page 51. Editorial finding that he has participated and cross-examined the management witness also. Which we are concerned only in of process.
Yes.
And regarding the averment also paragraph 8 and 9. That your petitioner states that in connection with the LS incident, the respondent one placed the workman under suspension by order 8/10/2005, and subsequently the workman was suspended on 26/10/2005. The your petitioner states the workman duly submitted his reply to the charge sheet denying the charges level against him, but the respondent not being satisfied with the reply, domestic inquiry has caused where the workman allegedly found guilty and he was dismissed from service by order date. So ultimately he participated. And regarding another ground
Which paragraph have you read
paragraph 9.
of the writ petition?
Yes. Yeah, awareness. Now, apart from the not following the due process of law, another ground they have taken, not in paragraph 15, 19 months. This is paragraph 19.
Paragraph?
19, no paragraph. Page 8. Married.
Page 8
Page 8, paragraph 19.
of?
Repetition. There you go.
Paragraph 19.
Yes. Married.
Yes.
That it is clear from the record as well as the real facts of the case that the charge sheet was issued to the workman on the report of one of the senior manager of the garden street as post. In the charge sheet, there are altogether 4 charges, including the charge of manhandling of the senior manager street as host. The said manager was present in the domestic inquiry and the deposed before the inquiry as the prime witness. Subsequently, the said manager himself accepted the inquiry proceeding as fair and lawful and accepted the conclusion of the inquiry officer as justified, and on the basis of the said inquiry, 3 workmen were dismissed from the service. It is clear from the above fact that manager under whose initiative the charge sheet was issued and had also deposed as a management witness in course of the inquiry proceeding. The findings of the inquiry officer were also concurred with the same manager and also had imposed the punishment of dismissal from the service of the concerned workman. The learned labor court failed to consider this aspect, which was very vital in this case, as is mainly cases of this. Honorable Supreme Court is of the opinion that a person cannot be judge of his own case. The apex court is of the clear-cut opinion that such action taken by the manager in his case is contrary to the
Yes.
principle. So this is the one of the contents on lordship. Lordship change the dismissal order. Is 20
Of,
replacement.
yes,
Just charge sheet issued by one Babul Suikia superintendent, that is lordship fine at page 63 of the LCR, signed by superintendent lordship Sri Babul Suikia. And dismissal order signed by Sri Sam Masood, senior manager. This is Sam Masood signature, so page 20.
It is also signed by S. Ghosh.
S goes 4. Sam Masood.
where do you get the name?
uh, Senior manager Sam Masood, lordship, page 20. Senior manager.
Yes,
So that contention is also wrong. Here in it, they have stated that the dismissal order was also passed by the S. Babul Soikia, charge sheet issued by Babul Soikia, lordship fund, page 63 of the LCR.
Signature as those also there in page 20. my lord.
This is 4. Sir, Masood's
Yes.
signature is there.
Masood also as those also.
And last ground lordship regarding or issuing the notice, lordship, already I have stated that a fresh notice was issued. And thereafter, expert analysis. So ultimately, the opportunity was granted, lordship, and regarding the discovery of charges, lordship, the labor court has already appreciated the judgment of the L.K. Verma as well as the Krishnapalli Tea State. Lordship knows the assault is also one of the ground lordship for dismissal. I can place those judgments. Wherever the Krishnapalli Tea State.
Krishna Koli is what citation?
2004 ASCC. Page 200.
Those conduct of the workmen to make a physical attack, there will be gross misconduct.
Paragraph 2 and
I think those have been laid down in Krishna Koli. For that, punishment of termination is for, yes.
same ratio lordship L.K. Verma, 2006 to SCC. regarding treating the superior officers. Okay, Verma is 2006 to SCC 269. Paragraph 23 to 26.
Hmm.
Workman was 2005 3 SCC 331.
Which one?
Murid Kalari of Bharat Cooking Co Limited versus Bihar Kolarim Kamgaon Limited.
Okay.
I was also studying one case, regarding expiry order.
Regarding the defense evidence lawsuit, it has already produced the WS filed by the union. But has been stated by the London senior family, that is also not done.
What is this judgment? South Assam Roadways. Which paragraph, Mr. Das?
Another aspect also regarding the paragraph 7.
Yes. Of?
Paragraph 7 of the requisition lawsuit that two workmen has already settled lawsuit in terms of the debts in the response to the debt statement lawsuit. This one also the directly has to obtain instruction.
Hmm.
I have already placed the instruction. There is no record of the state for other accused workers who have approached the management. And regarding Kidok Tosa, PF balance of rupees 1,01,127.17 is lying in the PF statement. And in respect of Banestor now, benefit of PF settlement of rupees 54,158 is paid. And Megnat Kumar, benefit of PF settlement of rupees 90,997.70 paid.
His is pending.
Is paid.
How much?
1,127.
PF is from PF authority.
That is
Not from the management.
that instruction I have already.
There is a
provided
PF.
to the So that is also wrong, lordship, that
PF
settled. And that instruction was in terms of this one of court's order, we have already handed over to the learned senior friend, and they have not settled anything that counter. That statement is also wrong.
The PF dues is from the PF authority, not from the management. Management has nothing to do with it.
The dismissal lordship that was upheld by the learned labor court, and there is a settlement is does not arise because that's why that is wrong. I have taken specific instruction.
Okay. Heard three as does. Learned counsel for the petitioner. Also heard three K Kolita, learned counsel for the. That's for number two. State is a party here. মোটামুটি here লিখিবা। As per number two, management, whereas three M Chetia, learned state council is present for. No, where is that? Three M Chetia, learned state council is also present. Para hearing is concluded, judgment is reserved. Yes.